Announcement of judgment. Item 14, supplementary list.
The writ petition is dismissed.
Obliged.
Item number 9, Lordship. Only adjourn for today, sir. Chapter 2. Procedural.
Item 9, we are not adjourning.
Exactly.
There's no advance request. So you renew the prayer when the matter is called. We have received advance information in item number 6, 8, 11, and 12.
For he, Lordship.
These matters we are adjourning.
আপনারা একটু কল করে নিতে আমার ভিডিও
Please renew the prayer when the matter is called. For others,
Item 11.
you see, in item number 6, 8, 11, and 12. Both sides are represented on the prayer made by Land Council for the petitioner. The matter stands adjourned today. List after 2 weeks.
2 weeks.
Yes.
6, Lordship. Item 6.
6, wherever there is adjournment slip, we have adjourned.
Okay.
Item 6, 8, 11, and 12. 4 matters, there were adjournment slips, we have adjourned that. Other cases, please renew the prayer when the matter is called.
May I pray the Lordship? My Lord, item number 7. May I pray for adjournment, my Lord, only for the day, my Lord.
Call
this
later with both.
You renew the prayer when the matter is called. We are not adjourning any matter where there is no advance request on Tuesdays and Thursdays, because we are listing only few matters. Very limited matters are being listed, so we are not adjourning.
May I plead your lordship, listing of a writ petition, your lordship. Now matter last came up on 18/1/2025.
It will come after 2 weeks, because we are hearing APSC matters, we are unable to hear this.
Any date, your lordship.
Give it.
Of like.
Master.
Lordship, praying for listing for FT matters on 26th.
Give it, it will come after 2 weeks, not in these 2 weeks.
Daily list, item 1 for hearing.
May I please the Lordship?
Yes. Yes, Mr. Dey.
My lord. Yeah, at first, my lord, I beg to mention here regarding the doubt created by the LBO, my lord. My lord, kindly see the LCR, my lord, page 4C,
Yes.
serial number 4, date of birth 1968, serial number 5, place of birth West Bengal. And my lord, whether question was in the serial number 15, whether migrated into Assam, there is a comment no. So my lord, whether reference can be sent for determination of the petitioner as a foreigner, this question is involved in this case, my lord. When he is not doubted to be a foreigner and he has not migrated into Assam because he hails from West Bengal. He is the filed WS taking a stand that he is from West Bengal, my lord. He was born and brought up in West Bengal. And he came to Assam in 1995 for a contractual works, my lord, in the Jagirot paper mill, my lord. He categorically stated in his WS that he hails from permanent resident of West Bengal.
Yes. But whatever be the reason, he was, this inquiry happened when the petitioner was in Assam.
Yes. He was at the Morigao district, Gagi Road, my lord. Village Nofala.
Okay, we'll answer that.
So, my lord, kindly see the WS, my lord, page 33. Paragraph 2, my lord, page 33. That the report of the verification officer that the opposite party
Because
entered,
we have a query, Mr. Day.
my lord,
Let us say there are 5 people who are apprehended, A, B, C, D, E. All say that, well, I have come from, one says I am come from Madhya Pradesh, one comes from Rajasthan, one comes from West Bengal, one comes from Kerala. Now, what do we say about the scope of the local verification officer? Will he travel to all these states and find out from where they are? Because and the references can't be sent from one state to another state. Now that person is admittedly present when the local verification takes place.
my- and he stated before the,
No, that's
Appli-
okay. That's why we are asking you. These 5 people are staying in 5 different states, and they are suspected to be foreigners. Now, can merely because of the statement that I stay in Kerala, a reference would be sent from here to Kerala. The person is admittedly here. Verification must be done where the person is present. You
my
see,
lord,
what is happening in United States right now? They're catching people saying that, well, we are canceling your visa, go back. He comes and says that, yes, I am from Guwahati.
yes, for this reason, my lord, he submitted some documents, my lord, in support of his claim. My lord, the voter list of his father, voter identity card, voter identity card of his mother, and the land documents, my lord, that he has property in West Bengal, my lord. My lord, only different, my lord, learned tribunal has disbelieved these documents because there is a, my lord, some difference in the name of his father. Sometimes, my lord, his father is recorded Darpan Narayan Karmakar, and in one place Darpalal Das and another place Darkhalal Das. But his actual name is Darpan Narayan Karmakar. Only that difference, my lord, his father's name, that's why they disbelieve
We
this.
come to paragraph 16 of your written statement. Oh, sorry, that is your evidence, not written statement. I think it's your evidence. No, your writ petition, sorry. Your writ petition. Paragraph 16,
16, my lord.
1-6.
Yes.
Petitioner states that the father's name recorded in various documents are so and so. All these names are same at one person.
Yes.
But this name is Darpanarayan Karmakar. That is not what you stated here. Karmakar word is again not there.
Darpanarayan, my lord, last of the Darpanarayan.
Correct, but
It is
your submission is that Darpanarayan Karmakar.
Karmakar.
That full name is again not here.
But in the WS, my lord, it is there, my lord. Darpanarayan Karmakar. The written statement, paragraph 6, my lord. Page 33. He has the land documents, my lord, page 22, Kotian. Page 22, annexer P3.
That is exhibit.
Exhibit, my lord, Cho. Exhibit Cho.
Here the name of the patadar is Manik Karmakar.
Manik Karmakar, Pita Darpanarayan Karmakar. And the minor revenue paying receipt, that is page 26, my lord, with respect to this Kotian.
Just a moment.
Kotian number 1231,
Just a
page
moment.
26, the revenue receipt.
Can you read the document? This is something I can't read. Your
My lord,
Khotian, where is that page number?
26.
This is not Chaw.
This is, my lord, revenue receipt
No, but page 26 is not exhibit Chaw.
No. Exhibit so is the, my lord, the Khotian.
Where is that?
That is page 22. Annexure P3.
No, something is wrong.
Well, my read petition, page
Something is wrong.
Manik Karmakar, Pita Darpanarayan, Khotian number 1231. So, my lord, it may be Cha, Ditya Sa. Sorry, my lord. The Ditya Sa. Petitioner father's is Cha, my lord. Petitioner's name is Cha, Ditya Sa. Page 22.
We wanted to know the date of entry.
Date of entry, my lord, it is
4794 is the date of attestation. And what is the date?
attestation.
What is the date we are unable
But
to?
my lord, revenue receipt, kindly see page 26, the same
No,
revenue
we-
receipt.
We are determining, we are on the basis of documents which are pre-25/3/1971.
My lord, kindly see Cho, annexure, exhibit Cho, that is page 18,
Yes.
page 18. My lord, here, it is his father's name, Darpalal Das. So, my lord, kindly see the note that is Riot. He was in the riot since 1360 BS, Bengali year. 1360 সন হইতে riot. That means it's amount to 1953, my lord. 64 attested. And it was attested in 1964. Has your lordship got it? The right hand side, column number 15, middle.
You see, we are finding it difficult. You see what, this document is as per the certificate given in this exhibit Chaw, this is a document which is prepared under the West Bengal State Acquisition Act 1954. Now, this act protects under section 40 and 41 persons who are riots. Now, if the entry is, you see, the Acquisition Act came in 1954, and the entry of riot, according to you, is this Bengali year 1360. 1360 would be what in English?
About 1953, my lord, it is 1953.
1953.
Yes. Current year is Bengali year 1432.
I'll take your word for it.
Well,
I don't know. Since you are saying it, we accept your submission.
Still, my lord, this land is under possession of the petitioner and his relatives. Still, they are residing there.
But after this Khatian, has the name been entered into the record of rights?
Yes, my lord.
Where is
It
that?
is, my lord, page 24. খাজনা দাখিলা এবং বিবিধ তলব। This Khotiar Jamabandi, this changed to, sorry, earlier it was Khotiar number 91, now it is changed to 107. Jamabandi number 107. Dorpalal Das Kormokar. And the rent was deposited by the elder brother of the petitioner, Viren Kormokar. And this document is, my lord, is a 15 BS, Banglasal, revenue receipt.
But in your written statement, you have not introduced your grandfather.
Grandfather's, my lord, Sargam
No,
one, it is mentioned, my lord, in the grandfather's name.
Because there is slight change in name everywhere. And that is why your evidence was rejected by the tribunal, saying that it's a document of convenience. Date of death of your father, your family members, nothing is
My lord,
stated here.
it is not well drafted in the WS, my lord. It is due to, my lord's,
Oh, whatever be, but
satisfactory not.
drafting is
Otherwise,
by,
my lord, petitioner have all the documents, my lord. Yes, all the documents. It is fact, my lord, that he hails from West Bengal. And since, my lord, 1950 upwards, he is there in West Bengal, his father. And the
No, but you say
grandfather.
unless you introduce your date of death, how would the name of the son come instead of the father? There's no substitution of
My
the
lord,
name of the.
latest position is that, my lord, that land was mutated in the name of his son, that is the petitioner. My lord, I have recently collected his documents, my lord. But at the time of, my lord, filing WS, it is not given.
Let us see that.
That land was mutated in the name of petitioner, my lord, Manik Kormokar.
Let us see the document.
Originally, it is 307, now it is.
Pass it on.
Khotian number 107, earlier, on the bottom side, it is written earlier Khotian 107. Huh? Both side. This is dated, my lord, 3/9/2020.
In this exhibit, George, how, whatever you want to show us, where will we find the pata number or dag number, whatever?
Khotian number, my lord.
Where is that?
Khotian number, my lord, 107, that is page 24. Jamabandi number 107.
But this 107 is not available in your the earlier pages of Khatian.
That is was 91, my lord, Khotian. It is changed to 107.
How do you find the connectivity?
My lord, page 18, my lord.
How do you find the connectivity? You see, in our state, we are accustomed to look at the documents of our state, where there's a Jamabandi, if there's a Chita, then it is entered there. So there's a link from one period to another period.
55, my lord, column number 5 of page 24.
Page 24.
Page 24, column number Mojar Nam OJL number 55. And in page number 18, Sanjay number 55. Sharasta number 55 is also 55. Page 18 and page 24.
Page 18 just show us where we have not been able to find out.
My lord, page 18, top,
Yeah.
top. Just serial number after serial form number 5062 next
Okay, 55.
below that
55.
page. Yes, 55. Saranjan number 55. And still in the current, my lord, paper also, a 55 is there. Moja Saranja JN number 55. Jela. Jela now. L number. JL number.
Anything more, Mr. Day?
My lord,
Anything more you have to say?
my lord. My lord, document says that, my lord, he has hails from West Bengal, my lord. My lord, in this regard, I beg to cite some citations, my lord.
Yes. But you see, the tribunal has rejected your case because of valid reasons. You produced your uh, father's and mother's, I believe, identity card. It does not have signature of the issuing authority, whereas your own identity card contains the signature of the issuing authority. So therefore, if your documents are not proved in accordance with law, rightly you were
My
held
lord,
not
these
to
are
be an Indian.
public documents, my lord. May I?
Identity card is not a public document, because this is issued to you, and you will also only have to you can only say, you see, there are 3 documents of identity card by Election Commission of India. We have until number of judgments where we say that identity card is not a proof of citizenship.
My lord.
Now, in Exhibit Kho, it's your father's, Karmakar Darp Narayan. Now, this does not have a facsimile signature.
Title,
Correct. And
Kormak
then you come
title
to
first.
your own identity card. It contains a signature.
Yes. In the mother's voter ID card, my lord, fascination signature is there. Page 16.
Mother is something you are not introduced in our statement. Yes, sir. That is not ठीक है, sir.
My lord, it is fact that he is still, my lord, landed property is there. His other relatives also they are residing there in the same land, which was he was a riot of the land, my lord, since 1953, my lord. His brothers and other relatives. Hmm? Yes.
But you see, though you are residing there from 1953, you have no voters list.
Voter
Electoral
list, my
roll-
lord, West Bengal voter list is there, my lord, but Assam,
Nothing was exhibited.
my lord, voter list, printed voter list is there, my lord, but it is not produced before the tribunal, my lord.
So this reference is by electoral registration officer. You wanted to get your name registered in the electoral roll. It came in the draft roll, and therefore revision. And in the
Well,
revision, the ERO suspected you to be a foreigner, and therefore reference was made. And in the reference, there's a printed column saying that you are suspected to be foreigner, and therefore I am detained.
Well, so far the Assam is concerned, as present address is concerned, my lord, that's. Otherwise, my lord, he stated before the LBO that he hails from West Bengal. And it is also recorded that he hails from West Bengal, his date of birth is so and so.
But they're not-
And then, my lord, important factor, my lord, it is clearly stated that he has not migrated to Assam from other country. Statedly, it is no, he has not migrated. He has come from one part of India to another part, my lord, from West Bengal to Assam. So in this regard, my lord, one citation is there, my lord. My lord,
Yes.
can be considered as a Anjana Bishar's case, my lord, categorically stated, my lord, that since a petitioner hails from West Bengal, so it cannot be said that the foreign country is specific country. Take the Anjana Bishar. My lord, citation is, my lord, 2023 2 GLT, page 1102.
2000,
2023 2 GLT 1102.
paragraph,
Paragraph 35, 119, 120, 121, 122, 125, 127. The same question, my lord, raised in that case. Paragraph 35, my lord. I একটা কপি আছে দিয়ে দেব একটা কপি দিয়ে দেব বলতেছি এত নাই
yes.
পাইলেও তো আছে।
Okay, you can read, we have it,
My lord. Paragraph 35, my lord.
yes.
Mr. So-and-so submits that in any event, there is a
Don't-
specific
don't-
mentioned in the inquiry.
Don't read wrong, she's Miss, not Mr.
Yes. Yes, yes, ma'am. Sorry, my lord. Report that her father resides in Calcutta and that the petitioner was born and brought up in West Bengal. And also there is no indication in the inquiry report that she had come from the specified territory, which is necessary for initiating and proceeding, any proceedings under the Foreigners Act, Foreigners Order 1964 in the state of Assam. My lord,
Just a
then
moment.
kindly see, my lord.
Just a moment. Next para.
Paragraph 119, my lord. May I read, my lord?
Yes.
The main thrust of the submission of the learned counsel for the petitioner has been that the petitioner is an Indian, born to a Bengali Hindu, namely so-and-so, a resident of village Palda, Muragasi.
Something is wrong. 119 is, it is referable to which, is it for a particular case or it's observation? Can you pass on
It is
the,
an observation, man.
pass on the printed copy?
My lord.
It's not tallying.
Petition. This was
You are referring to paragraph 119.
119.
Yes.
Yes.
You want it back?
No.
Acha, okay. Yes, please proceed.
Well, the main thrust of the submission of the learned counsel for the petitioner has been that the petitioner is an
No,
Indian.
but that is still not 119. 119, according to the copy you have given us,
My lord,
it appears from the evidence. That's why,
that is 27. My lord, in that case, my lord, page number 27, perhaps. Paragraph 119, page 27.
okay. Yes,
My lord, they are the born to a Bengali Hindu, namely Sri Onil Vishwas, a resident of a village Palda, Muragasa, P.O. Sapur Stupi, P.S. Kautali, district Nadia, West Bengal, who subsequently got married to one Ratan Sarkar, son of late Chintaranjan Sarkar, resident of so-and-so village, so-and-so district, Morigaon, Assam, in the year 2001, and accordingly settled in Morigaon. After Morigaon, Assam, after her marriage in the matrimonial home, and as such, she can in no way be treated to be a foreigner, in support of which she produced numbers of documents. In our opinion, paragraph 121. In our opinion, when such a plea is taken by a person hails from another part of this country and not from Bangladesh, such a plea must be considered with utmost seriousness, inasmuch
Mr.
as
Mr.
the
Dey.
tribunal,
Mr. Day,
my lord,
with all respect, this finding is incorrect. Please come to paragraph 58.
paragraph 58, yes, my lord.
Yes, below 58 is the reproduction of the ERO report, Annexure B,
Yes, yes,
correct?
yes.
You omit this whereas, and then come to number 5. Whereas I, electoral registration officer for the said assembly constituency, having doubt about the citizenship of the said person, got the matter verified.
Local verification officer.
Yes.
And
So there was a doubt with regard to his citizenship.
my lord, that was
No,
that
that's
was
okay.
considered. This report is considered by this judgment, my lord. 59. 59, my lord. However, we, however, fail to understand how the ERO came to such conclusion when it is specifically mentioned in the verification officer's report that the place of birth of the petitioner is West Bengal and her father resides in Calcutta, because of which she was unable to provide documents within sufficient time. The said reference was also was made based on the verification report of the LBO as mentioned therein. The said report of verification officer dated 10/9/1997 and the reference was made by the ERO on 13/10/1997. There is nothing on record to show that the petitioner was given time to produce the documents after she short time as mentioned in the verification officer's report. It is a Procedural claim. Procedural claims that she was born in West Bengal and brought up to produce documents from her father who resides in Calcutta. Such a claim cannot be considered to be unreasonable at all. In fact, the authority ought to have given adequate time to the petitioner so that she could produce such documents before the reference is made to the tribunal. There is also nothing to indicate that the ERO made the reference on the basis of materials other than the report of the LBO. In paragraph 60, my lord, we have made said observation for the reasons that such an inquiry was grave implications for the persons concerned, as also highlighted by the full bench of this court in Muslim Mandal. If a person was indeed born and a resident of any other part of the country, as in West Bengal, and even though large number of Hindu Bengalis may have migrated from the then East Pakistan, now Bangladesh, the specified territory, yet such a claim by the person concerned that she is ordinarily from West Bengal cannot be treated lightly. It must be considered with all seriousness it deserves. Verification authority, referred authority, and the learned tribunal ought to have taken so more care, as otherwise a genuine Indian citizen can be put to serious inconvenience and jeopardy, as appears to have happened in the present case. So he has come from 61 also stated, my lord, that we have noticed from the initial inquiry by the competent authority is that the petitioner had clearly mentioned that she was born in West Bengal and her father is residing in Calcutta, because of which she could not submit the documents in the short notice. Yet there is something to indicate that the ERO had duly considered the said claim of the proceeding before the ERO made the reference to the superintendent of police Morigao for determination citizenship of the petitioner. the inquiry officer or the ERO and the referral authority did not appear to have made any conscious effort to make further verification as regards the claim of the petitioner that she hails from West Bengal or wait for the documents. In paragraph 62, further, there is no findings by the inquiring verifying authority that the proceeding had come from Bangladesh. Merely because the proceeding is a Hindu Bengali and speaks Bengali, and also merely because many Hindu Bengalis and migrated from East Pakistan or Bangladesh, a person cannot be suspected to be a foreigner without proper basis and without undertaking further inquiry or verification, as otherwise such mechanical processing may have a devastating effect on the genuine Indian born in this country. And by that, kindly see paragraph 120. Paragraph 120. In our opinion, when such a plea is taken that a person hails from another part of this country and not from Bangladesh, such a plea must be considered with utmost seriousness, inasmuch as the tribunal will not have any jurisdiction to consider the claim of any person who does not hail from the specified territory within the meaning of Section 6A, capital A of the Citizenship Act. Paragraph 22, 122. And it was also observed in the Indira Newar's case that if no suspicion is expressed by the referral authority or in absence of any finding recorded by the concerned authority that any of the proceeding are persons who had come into Assam from the specified territory, such a proceedings will not lie. Though in the said batch of writ petitions, the matter related to the matters of Gurkha community who ordinarily hails from Nepal. Then paragraph 125, my lord. In our opinion, the same principle can be applied to other persons who have come from the specified territory. In our opinion, the same principle can be applied to other persons who have not come from the specified territory. In the present case, the petitioner claims that she came from West Bengal, which is not part of the specified territory, which refers to the territory in Bangladesh immediately before the commencement of the Citizenship Amendment Act 1985. Thus, West Bengal being not part of a specified territory, but a part of this country, no proceedings would lie against the petitioner before the Foreigners Tribunal. Well,
Yes, Mr. Pang.
My lord, may kindly see, my lord, the cross part of the petitioner first, my lord. That reveals the everything, man. On what basis the tribunal can declare a person foreigner? My lord?
Cross-examination?
Yes, ma'am.
Which page?
Page 36, man. May I read from the, my lord, examination part?
Yes.
So, page 35 onwards. Yes, my lord, he's the only person who came before the tribunal and adduced evidence, my lord, the proceeding. Is Manik Karmakar, son of Dorpo Narayan Karmakar, is aged about 42 years in 2013. when he deposed this matter. I resided present in Moja, Nokhola Grant, place Jagirut, Police Station Jagirut, District Morigaon, Assam, where I'm a contractor on order. I'm the opposite party in the case. I was born in village Gopalpur in the district of Uttar Dinajpur, West Bengal, where I was read up to class 5 at Madargasi High School. Exhibit Co is the school certificate. The proof of casting vote has given in the name of my parents by the election commission in election of constituency. I am casting vote. Exhibit Co, Go and Co are the voter cards of my father, mother, and myself respectively. The ration card is issued in my name, village Gopalpur in the state of West Bengal. Exhibit was the ration card. I have submitted the copy of Patta of land of village Gopalpur in the name of father and myself. Exhibit So is the copy of Patta of land of my father. Exhibit So is the certified copy of Patta of land in my name. Exhibit Jo and Jo are the land revenue receipt of 2009 and 2012 respectively. The Damahana Panchayat issued a certificate that I am a resident of Gopalpur. Exhibit Nyo is the said certificate. I have been working in the paper mill at Jagirut under a contractor since 1995, though I am residing here for livelihood, but I have been casting vote at village Gopalpur. I am residing in rented house at village Nokhola Grant under Jagirut. I am not a foreigner, I am a citizen. That is not cross-part melon. I am working under the contractor namely Ranjit Singh. In Exhibit Co, the West, this is my W Disnapur. Maybe probably W means West, my lord. Maybe, my lord. W Disnapur is written in the top in the said certificate. But in the said certificate, it is mentioned at Uttar Dinajpur. In Exhibit Co, has mentioned the name of 2 districts, and my father's name is written as Darakslal Karmakar. Drakslal Karmakar. As per Exhibit Co, my date of birth is 1/5/1972. In Exhibit So and So, has not mentioned the year of which it were issued. So these two documents, So and So, which my learned senior friend is saying to be the Jamabandi and Khatian. Those are, there is no date. It is admitted by him. And in fact, it cannot be seen from the record also. In Exhibit So, is written Dorpolal, son of Sorgo Mohan. In Exhibit So, Cho, it is written as Manik Karmakar, son of Dorpo Narayan. My grandfather's name is Sorgo Mohan Karmakar. Sorgo Mohan. I have not submitted any voter list in the name of my father and myself. In Exhibit Ngo, the ration card, my father's name recorded as Dorkho Karmakar. And my name is Manik Chandra Karmakar. In Exhibit Kho, my father's name shown as Karmakar Darpo Narayan, son of Darpo Narayan. Karmakar Darpo Narayan, son of Sarga Mohan. And in Exhibit Kho, my name is shown as Kanik Karmakar, son of Darpo Narayan. In Exhibit Kho, there is no facsimile signature, but Exhibit Kho, there is facsimile signature, but Exhibit Kho, no facsimile signature. In similar, there is no signature in Exhibit Kho. My mother's name is Sinta Rani Karmakar. So it reveals, my lord, from the record, if we see, my lord, there is not a single document to show that the either father or grandfather was prior to India, in India prior to 1971. There is no documents at all. That is the first point. Secondly, to link himself, my lord, he has to, otherwise he has to prove that he is in India prior to 1971. There is, my lord, he admitted his date of birth is 1972. And he could not establish, my lord, that he was born in India. And he exhibited a certificate, my lord, that school certificate that is not proof by any means. First of all, there is no documents of pre-71 because he had submitted to my lord Khatian, but those are not dated. And the, my lord, the revenue receipts are of 2009 and 2012. Revenue receipts are of 2009 and 12. So on this basis, my lord, first question is the petitioner, my lord, the tribunal cannot assume or presume that the father of the petitioner was there in India prior to 71 without any documents or without any evidence. That is the first issue, my lord. So if father or grandfather's existence in India is not proof, then no question of proving other aspects also, my lord. First of all, he has to prove that he is in India prior to 1971. Or his parents are there. That aspect is not proof. Secondly, to link himself to the projected father or grandfather, whatever it may be, my lord, he could not prove any documents. He only brought my lord, the school certificate that was not proved. And the school certificate, if you see, my lord, from the school certificate, this certificate was issued. This page 20 is the school certificate, my lord. Here, Manik Chandra Karmakar is the student, and Daksal Lal Karmakar was the father, shown to be father, and village is Gopalpur. And according to this certificate, he was, as per as he left the school on 31/12/1981. And this certificate was issued on 30/11/2012. After 30-40 years.
No, this is attested then. Is issued on 4/11/92. Signature of the headmaster is
date of living is
4/11/92. Date of attestation is
Yes,
30/12.
92. Sorry. 92, madam. Date of attest, it is later on attested in 12. And this certificate is not proof, madam. This is not proved by either by the writer or by the school authority. Secondly, my lord, even though it is proved also, my lord, the first thing he has to prove that Daksal Lal Karmakar, whom the petitioner is projecting as father, existence should be there in India prior to 1971. And the tribunal is right, my lord, as well as because the petitioner himself in the cross-examination sheet in exhibit saw and saw, my lord, those two are the my lord, the land documents showing that the father and petitioner's name are recorded in this page 18 and page 22, my lord. But there is no date mentioned. It is evident from the document also.
Which one?
Page 18, my lord.
Page
18.
18. Yes.
Page 18 to son. Sort of. Sort of. Son to 18. No, so. From sort of. From sort of 18. So admitted that, my lord, there is no date mentioned in this document. Date of issuance of this document.
No, date of issuance is available. Because this is a certified copy.
Yes, certified copy. Certified
Sure.
copy is issued.
12/7. This year I can't read. It is there.
This is certified copy. 12/7 something is there, Malad, that is not clear. But Malad, when this patta was issued,
Attested in 1964, 3/2/1964.
put aside.
Both. এই যে টাঙ্গরকে seal মারা, attested. 3/2/1964.
Whatever it may be, Malad, but he has specifically admitted date of issuance of this patta is not there. Either
This
it
is a Khatian, it's not a Patta.
yes, Khatian is not. This is Khatian, Malad. And the revenue receipts are of 2009 and 2012. So in merit, my lord, there is no case at all. Now, my learned senior friends, my lord, argument that this may not be the LVO report was not LVO report is not proper and no reference can be drawn against the petitioner because apart from these documents, my lord, they could, your lordship has rightly pointed out, they could produce any documents of the parents, either of the parents or of the grandparents, my lord, of prior to 1971. If they are originally, my lord, either from West Bengal or from Assam, they could produce those documents. It is not that they were not given opportunity to produce those documents, my lord. Because this case was initiated, my lord, way back in 1997. And this is ended only in, my lord, 2013. This reference was initiated in 1997 under IMDT. And this was ended on 16/5/2015. So there is long period, my lord.
What is one more?
In fact, in WS also, my lord, she has not pleaded that her parents and grandparents have any voter list or any documents of prior to 1971. Apart from the discrepancies in the name of father, grandfather, in exhibit saw, the pottadar is not Dorpolal Karmakar, my lord. It is Dorpolal Das. And the father is Khorgo Mohan. And exhibit saw, if we want to link both this, my lord, exhibit saw, the petitioner's name is there as Manik Karmakar, but he is son of Dorpo Narayan, not of Dorpolal Karmakar. There's a huge difference. So apart from these discrepancies, my lord, the petitioner could not establish that this father was there prior to 1971 in Indian soil. And in WS, my lord, para 6, the petitioner is firm enough to say that his father of the opposite party is Tarpo Narayan Karmakar and is a citizen of India, is legal voter, is holder of identity card from Election Commission of India. That is the statement, my lord. There is no other statement that the Tarpo Narayan Karmakar is also known as some aliases, my lord, in WS. Now, while bringing these documents, filing those documents, my lord, the father name is different in different documents. That is the issue, my lord, on merit, my lord. And another aspect, as my learned senior friend has argued, my lord, that this LVO report is not conclusive, and LVO report has not indicated that he has come from East Pakistan. So he should not be, my lord, sent to the foreigners tribunal. In fact, my lord, that my learned senior fellow also referred to my lord Anjana Biswas. My lord, with all respect to that, my lord, justice, my lord, judges of that bench, my lord. My submission will be that, my lord, judgment has not considered some aspect, my lord, which your lordship may kindly see. Because this is settled provision of law. And if it is not considered, it may become par incuriable. Because, my lord, my lord, as your lordship knows, my lord, during my lord 1997, extensive revision was done on the basis of direction of the my lord, Election Commission of India. And it was the guideline of the Election Commission of India which was followed. As I have read earlier also, my lord, in the guideline, I have submitted this guideline earlier occasion. I can also submit, my lord, but I have to submit it by way of my lord email. But made it only one point, my lord, with regard to verification. What was the guideline? In 8.8 of the guideline, it is, my lord, 8.8 of the guideline. Same guideline in 1997 and 2004, my lord. It was published again in 2004. The election registration officer cell, my lord, what is verification officer's report and election officer's report? My lord, the verification officer, there is a verification report by the verification officer. But what he has to do? He has to go to the person's house, my lord, or where he is residing, my lord. He has to verify, and whatever he reported, my lord, that has to be noted down. He cannot, my lord, if, my lord, I go to the person who is suspected, if he says I am from West Bengal, I cannot write that, my lord, he is from, my lord, East Pakistan. Whatever he stated, I have to record because it is verification, not my inquiry report, not my inquiry. It's a verification report. So what the Election Commission directs, my lord, as I have already said it again and again, my lord, the EROs are not, the my lord, verification officers are not, my lord, persons from election office. They are independent person of government servant. They are given this duty. So there cannot be bias because they are not elections, my lord, election officers person. Now the election registration officer cell, on receipt of the verification report from the local verification officers, that is LVO, my lord, consider the same. He has to consider the same, my lord. He considered the report of ERO, where he is satisfied on such report. Now, my lord, dissatisfaction, he has to be satisfied on such report and such other materials information as may be available to him about the eligibility of a person, he shall allow his name to continue on the rule of rule and include in the final rule. This is the point, man. In 1997, this person's name suddenly appeared in the voter list at Jagirul. There is a doubt arises. Well, his name is put D therefore. Then local verification officer was asked to make a verification whether his name can be continued in the voter list or not. That is the question, my lord. First question, whether his name can be continued in the voter list or not. Then LVO has to go. LVO make an inquiry, my lord, verification. If in verification, LVO can collect documents and submit before the, my lord, ERO, it is the duty of the ERO to allow him the name of the person to continue in the voter list. Then it is again said, my lord, if he is not satisfied that he could not, the LVO could not furnish proper documents, enough documents to continue his name, there is no alternative but to send the person to the foreigners tribunal for, my lord, determination. That is the point, my lord, only point. Now, second point, my lord, I supposed to refer. The Honorable Apex Court in Sobananda Sunwal 1, my lord, 2005, 5 SCC 665, in para 41, 42, it is said, my lord, this verification report, in fact, the verification report in that form, my lord, which form it is there in the present, because these are, my lord, arising out of IMDT. As I have already submitted once, my lord, these all forms are of, my lord, IMDT derived. It is derived from IMDT on. And the Honorable Apex Court says these informations cannot be derived by the investigation officer or by the LVOs while, my lord, making the inquiry, because they are not going to disclose all these things. That is what, my lord, Sobananda Sunwal has said. Para 41 and 42. 42 clearly said, my lord, it is elementary that, para 42 said, it is elementary that a person who has illegally come from Bangladesh to India and is residing here for his better economic prospect or enjoyment, etc., would never disclose that he has come from Bangladesh. He will never disclose, but would assert that he is an Indian nation and resides in India. That's why, my lord, then it is said, there is no question of his telling his date of entry or giving any information on the aforesaid points. After considering this, all this aspect, my lord, the Honorable Apex Court has set aside the, my lord, IMDT as well as these forms. So whatever in the forms, my lord, those may not be, my lord, the mandatory as on now. Because the Sobananda Sunwal has said these are illegal. You cannot elicit this, my lord, this informations from a suspected foreigner. He is not going to disclose all these things. So, my lord, third thing, my lord, what my submission is, a genuine citizen of India should not be, my lord, disturbed in any manner. That is true, my lord. But it is their duty to prove that he is a genuine Indian with all his documents. If he can prove that he is from West Bengal, my lord, because, my lord, this LVO report was done in 1997. Since 1997 to 2013, he got enough time. It is not that, my lord, LVO has done. After this completion, he has been sent back. No, LVO report was given. He was put under D. D was continuing for 2013, since 1997 to 2013. 2013, he was given opportunity to prove himself. He could not bring any documents in 2013, after 10-15 years. And it is their duty to prove all these documents, whatever documents he has brought.
Give us a copy of that guidelines.
Yes, I can, I will send by email, madam.
Give a copy to Mr.
Yes,
They also.
yes.
Okay.
Okay, then.
But Mr. PC Dale, counsel for the petitioner. Mr. Response to that, Mr. J. Pang, Mr. Sharma, Mr. Kudi. Arguments are concluded, judgment is out. Anything in reply you want to say?
My lord, one thing, Sarbananda Sonowal's case, my lord, in paragraph 55, it is also mentioned, my lord, in 2007 case, my lord, Sarbananda Sonowal, that is 2007, 1 SCC, page 174. paragraph 55, my lord. My lord, it is clearly stated that there cannot be, however, any doubt whatsoever that adequate care should be taken to see that no genuine citizen of India is thrown out of the country. A person who claims himself to be a citizen of India in terms of the Constitution of the India or the Citizenship Act is entitled to all safeguards, both substantive and procedural, provided therein to show that he is a citizen of India. So safeguard, substantive safeguard as well as the procedural safeguard should be there, my lord, for the protection of the citizens.
We are reserving the judgment. We'll take a short break and come back. Yes, item 2.
Lordship, Mr. P.K. Roy is engaged in his case. He is on his legs in custody. It will take some substantial time.
Okay. After some time.
PC is requiring this case. He is also in legs. It will take the entire day, that hearing put number 10. We have to proceed in some other day. This entire day he will be in the legs in put number 2. It can be proceeded on the first.
This day is extended to June. Hmm? You take the convenience of Mr. Roy. Can you fix it on 3rd of June?
Yeah.
Okay. Both sides are represented. The it is submitted that the learned senior counsel for both sides are on legs in different court. Accordingly, matter stands adjourned today. List on 3/6/2020. 5.
Okay.
Item 3 for hearing.
After receiving summon, I appeared with the tribunal. I filed this statement. I filed DW1 myself, and 2 my mother, 3 my brother, and 4 is Gaupranagar. And after that, the implement order passed by the tribunal on 15/2/2020. Page 40, 48. In this case,
Just a moment. You see, there appears to be a finding in paragraph 12, exhibit the school certificate, they were discarded.
Discarded.
It was not proved by the authorities.
And admit card, that was no.
But otherwise also these are post 25/3/19.
No, there is a link proof here is there, no? Link is here. And my father name is appeared in 1970, and was 66, and mother name appeared in 1989. As because they after 70 there is a shifting from Behra to Mandia. That was under same police station, probably, yes, same police station. District is same. So there is a gap in border list. And my brother PW2 is PW3.
But Mr. Rashid, there's a disconnect. You have not been able to show anything.
In the F3.
Where is the 1966 voter list?
Page 49,
9.
my lord. And hearing only the name of my grandfather and father appear, my lord. And also my uncle's name was appeared. Sir, there is a serial number.
What is the name of DW2?
DW2, my lord. Yeah, his mother, my lord. His name, her name appeared, my lord, 1989, first time.
No, it's okay, but what is the name?
Name, my lord, kindly see page, my lord, 61.
So just tell us the name.
My eyes, I mean. Anwara,
Anwara.
my lord. And petitioner father name, my lord, Sarbot Ali alias Sharaf Ali. But Ali Ahmed Ali, etc., my lord. But there is two names or three names. Here, my lord, serial number 572.
And where is the 1989 voter list?
My lord, yes. 89 voter list, my lord, kindly see page, my lord, 61. Annexure 14.
51.
161,
61.
my lord. I will forgot it. And 1966, they were Miller at
Just a moment.
my lord.
Something is not matching.
Wrong thing, maybe. But in my petition, Miller, I have find
You come to page 16.
16. My lord.
Page 16, your date of birth is 1/7/1978.
I think 1/7/1978.
1988. Now,
78.
78. Now come to page 11. In page 11, you are 41 years on 20/11/2020. So that will make your year of birth on 1989. It's a difference of 11 years
11 years.
between page
11 to
11 and 16.
No, I'm allowed to calculate the same Miller, yes. But his Miller admit card is there. That is the original photoshoot copy, of course. Page 55 value similar on purpose, and that will be the correct. It may, my calculation may be wrong, Miller. But 55 1/7/1978.
Who is Nazimuddin Ahmed?
He is my elder brother.
He's your elder brother.
Well,
The school certificate was not proved by calling the headmaster.
my lord. But admit Miller, that is there Miller, and mark sheet also given by him. My mark sheet is not so my thing, maybe, but name is there. And he passed the matriculation HSS examination, and governor certificate that was examined by the issuing authority. And voter ID given Miller, he himself and brother and also mother. But those are also, I think, your lordship may not. No, Miller, if he is Miller born Miller on 1/7/1978 and 20 Miller 2020, he Miller there is another 40 22. So it comes Miller 41 or 42, not much more Miller bro. Oh no. fine. 11 বছর can be different one. 11 বছর can be different one. তাহলে করে আছে। হ্যাঁ? না, আমি 70 এর জন্য। আর this is level বেশি কিনা না। Like was 44 years, 42 years old. কম বেশি 41 plus half হয়। Or 42 হবো, 20 hours, 42 হবো। S2 সামনা, okay. S2 সামনা, that's nice.
Please read paragraph 11 and 12, page 45. And where is your written statement?
Registration millet, annexer millet 1, page 12 millet.
Page
12.
but your name is not there in any of the voter list.
My name millet.
So how you are connecting yourself to your projected parents?
There is millet a school admit card. And Gavra certificate.
Gabra certificate is exhibit number.
There is millet in my fiction millet there is a Gavra certificate millet annexer 12, page 57. And exhibit Q.
Q.
Q. My voter list also name appeared millet in 1997. Page 51 millet, you know, can see.
Just a moment.
With my father, mother, brother, and sister.
Which page?
Page 51 millet.
51.
Annexer 8.
No, this is not correct. Exhibited document, exhibit D is something else.
Exhibit D, my lord. No, I have checked the record today, but I found this document is there, my lord, yes.
Total list of 97.
My lord,
This is the exhibit number.
exhibit number here. I cannot, but in my petition, I have annexer, the annexer B, annexer 8.
No, you come to page 42. 1997 voter list is exhibit D. This is what is there in exhibit D, page 36.
Yes, my lord. 1997 voter list, yes, your lordship, that is annexer D, yeah.
Yes. We are sending you the LCR, it is at page 36. That is it. Page 36 doesn't tally with your document.
36 the record, my lord. Now, 36, that is the, my lord, evidence in siege of the schools. But morning, I have checked this in check, my lord.
No, you check the document exhibit D. We have shown you page 42. Page 42, sorry, 42, certified copy electoral roll of 1997 is at page 36.
D. That is the blue logo. This is 1997, yes, my lord. This is, in this case, my lord, I have seen from record, the name of my brother, father, yes, mother, and my elder brother. But in Bhanegalar one, there is the name of my name also there, my lord. That is, my lord, morning, I say, yes.
This page 26 doesn't contain your name.
I come, my lord, yes. Here is no name, but I have seen more, your lordship's record today morning. My name is there, not in Bhanegalar.
No, that was never exhibited. Even if you have a document, it is not exhibited, you come to page 13.
This is the exhibit Q, is the Gaura certificate, yes,
No, forget that. Come to page 13, 1-3.
of the record, my lord.
No, of your brief.
My lord.
Now, paragraph 9.
Then the second part is father name Soravali and mother's name is another brother Najimuddin, and their name have appeared in the voter list of 1987, so and so and so. House number so and so and so and so.
This is what you have said in your evidence.
I have, yes. And prayer team, that the second part is father expired and mother name Anwar Khatun and brother Najimuddin, Amel Sufi Ahmed. Older sister name is elder sister name is Jahanara Begum, and their name has been have been 10 voter list.
And somewhere you have said, where I will not be able to recollect, somewhere you have said in 1997, your name appears at voter list D. D mark in your voter list appeared in 1997.
No, yes, I have checked me out and
My sister has found out. It's paragraph 13
of my petition, my lord.
of your written statement. So that is why when you are D, you will not exhibit that because you never called for the records. certified
The-
copy.
Actually, what happened, your lordship, one thing knows, when D is put, my lord, if certificate to be applied, my lord, that
No, we
D
are only
mark
on one thing, Mr.
both is
Rashid.
not given.
The document you are annexed doesn't tally with that. The document exhibited.
I am coming, my lord. And the second party's name was marked D, doubtful D also, April nineteen
It's okay,
97.
but it was never proved. So your relationship with your projected parents were never proved through any document except
No,
that.
that is Gaura proof, my lord. Gaura proof, Gaura, and he also examined in the court, my lord, and also moreover, my lord, the
Where is this evidence? Gambura evidence?
Gaura evidence, my lord. DW4, my lord, kindly see Nipul Das, annexure 5, page 37.
See page 37, last line, last paragraph. I, without any verification, mentioned that Saravali and Sarbatali is one and same person.
Thirty-seven last page, last sentence. No date has been mentioned in the signature signature I put in the certificate. The opposite party had not submitted any application to obtain the said certificate. Neither any relevant documents were given to me. I, without any verification, mentioned that Saravali and
And this
Sarvodari.
person has destroyed your entire evidence, because in paragraph 2 of his examination, he says that the certificate was issued by me on a printed paper pad of Lohit Das, who is my father, by entering some contents on it. These contents were not entered by me in the certificate.
Opposite party Azimuddin is known to me. He is from Mondia Gao.
No, but this certificate is issued by him on a different letter pad. He's a good friend of yours.
But in certificate that is page 58 in vernacular. Yeah, that is he has himself given. Azimuddin Ahmed, Pita, Soravali Ahmed, Mundia Gao, Kothar Sanson. মই উক্ত আজিমুদ্দিন আহমেদ দেউতা শরবত আলী ওরফে সৌরভ আলী আহমেদ মানুহজনৰ একেই হয় মই জনা মতে সত্য it is his own statement.
We understand, but you see, Gambura is Lohit Das. He's not a Gambura. He issues a certificate. He's an imposter. Look at page 58.
78.
He even signs his charge number 10.
Charge number 10, Lohitdar is Gagura, signature is by Nipul Das. Your lordships.
The certificate goes, Gambura certificate goes. So only thing remains is that
Admit card,
metric admit card.
my lord. And that will not.
Just send back the original records.
I'm coming. Only one I have seen morning and now it is not there. So
No, it's okay. We accept your contention, but it doesn't help you.
it help, but of course that is there. But as and when I have said your lordship that my name is there in 1997 voter list. অসমীয়া ঘটনা থাকে নহয় সেইটো মই নিজে চাগে ক'ত যাব ক'ত কি যেগুলো তো কোনো নিয়ে নেবো There is another link certificate, there is school certificate, not, but that was not examined, but it is HLC pass certificate. And date of birth is mentioned, father's name is mentioned. Petitioner mother purchased land, but there is a approach cut-off date, 15, 12, 71.
Which page is your that school certificate?
School certificate will not, admit card is there, school
Ah,
certificate.
where it is?
That is will not page 55.
55.
Well,
Something is wrong. Doesn't tally because this is something I did not see earlier. Your evidence is at page 17.
17. My lord.
Correct.
My 16 years.
17 is your affidavit
Hmm.
on evidence. Now come to page 19. What is exhibit F?
Voter ID,
Voter ID. Next is HSLC admit card,
admit card,
correct?
my lord.
Now, we are sending you the records again.
Dan Miller, there is annexer on, see, there is
No, that's okay.
Right,
We
right.
are not on that. We have crossed that part. Now come, we are sending you the records. We showed you page 59 earlier. Now we are showing you the other documents. Back. Photo ID please. Everything is because- Yes, sir. This is because- Which- Exhibit G, exhibit G as certificate. G, into equipment education, it is school certificate. It is coming here. It's good for me. Yeah. No, give me the head and neck, sir. Yes. Now I will show you what has happened here. I was searching for it, but I couldn't recollect what has happened. Now we have noticed it.
My lord.
Mr. Pang, this was for you also. Look what is happening. Please open up page 19 first of your brief.
My brief, my lord. Yes,
Yes, 19 is open.
open.
Now, exhibit F is the electoral photo identity card.
Voter ID.
Yes, now turn over to page 60 of the records. Sixty
Hmm.
is a school certificate,
Admit.
metric admit card,
Admit.
correct?
Yeah, my lord.
But in page 19, it is a photo identity card. Now come to next, exhibit G, paragraph 10. No, in your brief. G is the HSLC admit card,
My lord.
correct? G, there is a school certificate. Now next is para 12 of your brief. H and I are Gaonpura certificate. Exhibited document, exhibit H is the school certificate.
Then who has committed the mistake, my lord? That is to be.
I don't know. Something was not
His
matching.
Red marking and member, it is definitely not our from our side and also not my learned friend. And it is not record was in their office. And these are exhibit A is the Millard mark sheet. And here I have Millard. The two certificates has been issued by the governor of village Behra Mondia. That means there is two certificates, one is from Behra, earlier village, and present one is in Mondia. H and I. But here H is that admit card, mark sheet. I again will add in voter list of 1966. That is only it is from the office who has marked it. Again, exhibit J, it is a 1970 voter list, and here is what I have mentioned. Exhibit J. Name declaring affidavit. Page 20. Name and else declaring affidavit. And exhibit K is the voter list of my mother, voter ID. Then my voter ID is not here. It should be there, my lord. Annexer, I was marked here, my lord, and place on record. And wherein, my lord, my name is there, my father name, mother name, my lord, all are here, my lord. Brother, sister. But this document, my lord, exhibit is a annexer one. All right. Myself, myself.
There are 2, 3 minor errors committed by the tribunal, but those don't go to the root of the matter. But Mr. Payang, if the documents are incorrectly
I have, my lord, exhibited on my voter ID, my lord, that voter, but that is not found available.
You see, something is again amiss. In the opinion, Mr. Pang, Mr. Pang, this voter list, the passport of his brother was produced by the mother, right? Come to page 23 of the brief.
Mother.
This document is not found annexed here as exhibit in the evidence on affidavit by DW2. He also next come to evidence of this Nazimuddin, the brother. He also does not exhibit his passport, but in the records of the tribunal, the passport is exhibited document.
Thirty-five. 35.
Hmm?
Yes, right.
Is 35.
Type to be like.
Photo sign করেছে। What was examination? Examination. On examination. On examination. No. Evidence for a examination. Okay, I'm going to okay, for it. Hmm? Hmm. Hmm? Something is wrong. Mr. Payang, look at the record again. Look at the order sheet. Now this this page 35 is an examination by the tribunal. Now look at the third page of the order sheet. There are some documents which are taken away. Third or fourth page of the order sheet.
Certified type copy.
This is a long list. Original documents are taken away. No, in the order sheet of the tribunal. No, At the end of the proceeding. Yes, correct. Now, what are the documents taken away? A to O. Huh? That means this passport was produced. Now, this page 35, you will come there in the affidavit of DW3 in the record. In the backside of DW3, the tribunal writes examination. And this is recorded, DW3. These documents are introduced.
Yes. Passport is introduced by the exhibit M.
No, but then you see the paragraph 14 of the judgment. This, when the passport is proved, somebody comes and says that I am the brother. The tribunal rejects it only on the ground that the document does not show that the father has two names. That is an oral evidence. So this is wrong. Yes. Last 5 lines. These documents are exhibited by witness DW2 Nazimuddin. He is not DW2, he is DW3. Nazimuddin, all the documents appear Nazimuddin, son of so and so. It does not show that Sarwatri and Sarabha is the same person. Definitely, there is an oral evidence given. But then the finding is wrong. DW2, he writes DW3 written DW2.
Madam, it is admitted position. In the passport, madam, the father name is different.
No, but you see, he comes as a brother. He says that my father's name is 2 and he gives his passport. So that passport is accepted. There's no cross-examination. There's no doubt created.
Passport. Actually, passport Ahmed at Nazimuddin of Mondia. Assam issued dated on 17th. Now, mother, the documents exhibit as DW3, Nazimuddin, and 4 documents appear Nazimuddin.
Come to page 30. Come to page 33. Come to page 33, paragraph 11. This is evidence of DW3. He says my father's name is so and so. You have to reject that one.
Sharbat Ali.
Now you see in somebody's name, he's writing A, son of B. And you are rejecting it that in this document, son of C is not written. But he gives an evidence saying that my father's name is so and so, written as so and so in other documents. And he has re-exhibited all the documents. DW3, please come to it. He has exhibited all the documents of this brother. Exhibit A, B.
Sarab Ali Ahmed and Sarab.
But that is Supreme Court has approved of that.
is accepted. I'm not that. Now, if you lordship kindly see what is there in 1966 and 70, they have to link them with 1966 and 70 document. That is not there.
No. You see, paragraph 11 says something more, which you read. Are one and same person. That is my father's name. My father was an advocate.
No, Edward Clark.
Oh, clerk.
Yes, Edward.
Advocate clerks till his death. Card number is not given. So therefore, his father has an identity.
At the time he expired, Virat, so probably that card number may not be there. And so he was,
What Pali? 1966 is Sardakal. Son of Mansoor.
We'll take it up some other day. Because you see, all these witnesses, 1, 2, and 3, they all say that father has 3 names.
father is same Millard, and there is no any dispute regarding voter list of 1966-70 and other voter list. And there is no any cross examination.
We'll take it some other day because we are running out of time. Both sides are represented. All sides are represented. Heard the submissions of Mr. A. Rashid and counsel for the petitioner, whose submissions are concluded, reserving right to reply. At a positive time, the submissions or respondents could not be heard. List, make it after 2 weeks. In the meantime, that those will be over. List on so and so as part of matter.
Fifth.
These discrepancies, can you keep note of it? After some time, I may not remember it. Address us on that also. Discrepancies in the marking of exhibits.
Marking, it's matter of your lordship. It's matter generally the advocate used to put the mark. This is the normal.
No, whatever has happened. But you see, the tribunal is marking something else and determining something else. So does it call for a remand?
It's is exactly the same. They are,
No, not the same.
well, they are marking manner.
Exhibit F, G, H. These are totally different documents, not serially marked.
Item number 20, I will not take much time. I was given the brief the other day. I've gone through the submissions made by the learned counsel. I find, my lord, this covers my case. Only one point I would like to state.
Mr. Das, which will be your matter?
26.
26.
26.
26. Short point, so I'll be relying on one judgment, 1999 TSCC 60.
26 is writ appeal 128.
Yes,
150.
Kunal Das. Hello, make push.
Just a moment. Yes.
I am on the, my lord, whether it is a simpliciter or a stickmeter. My lord, if it is a simpliciter, my lord, if the petitioner, my lord, files an application for employment in High Court, I'm sure High Court is going to take him, consider his application. Now, question is whether High Court or any other institute, whether going to take them, consider their applications in the facts and circumstances of this. Simpliciter means this, my
Mr.
lord.
Das, you know everything.
No, I'm
No, not that.
I'm on the basis of
No, not that. You know everything. You know some person who was qualified for grade 3. then became disqualified for grade 1.
That was not there. But as per law, my lord, person who is just terminated, my lord, and the simpliciter, my lord, their future is to be considered, whether they are going to get their service in the future one. I'll rely on that one judgment and I'll not take much of your lordship's time. 1999 3 SCC 60.
1999,
3 SCC 60.
3 SCC 60. The name of the
Now-
party is Mr. Das.
Party's name is, my lord, Dipti Prakash Banerjee versus Satyendranath Bose, National Center for Basic Sciences, Calcutta and others. Here, my lord, facts are like this, my lord. Some order was passed terminating him, that is in few lines. I'll not go to the facts, my lord. But later on, my lord, some show cause notice was also issued and termination order was passed. One mode of termination, your lordship may find it at paragraph 14.
Just a moment, there's some glitch. Yes, you got it.
Paragraph 14 is the order of termination. There's some lines are there, my lord. Since the performance during the initial period, etc. This was not interfered with by the learned single judge and the division bench. Paragraph 14. Then, my lord, your lordship will kindly see the matter came before this court. Court, my lord, paragraph 20. In this case, my lord, the reason was there that some inquiry was there and all those things. Paragraph 20 is as regard, my lord, termination simpliciter. I'll read paragraph 21. Yes. Paragraph 20 says, my lord, if a proceeding starts, my lord, they may drop the proceedings and simply terminate the persons. It doesn't harm the person, my lord. He is entitled to get a job elsewhere. Civil consequences is not there. Now, paragraph 21, my lord, I'll read, my lord. That is paragraph 20. Paragraph 21, if the finding, may I just read, my lord?
Yes.
If the findings were arrived at an inquiry as to misconduct behind the back of the officer or without a regular departmental inquiry, the simple order of termination is to be treated as founded on the allegations and will be bad. But if the inquiry was not held, no findings were arrived at, and the employer was not inclined to conduct an inquiry, but at the same time, he did not want to continue the employee against whom there were complaints, it would only be a case of motive and the order would not be bad. Similar is the position if the employer did not want to inquire into the truth of the allegations because of delay in regular departmental proceedings or he was doubtful about securing adequate evidence. Now, paragraph 24, the contention of the appellant is that if the appellant is to seek employment elsewhere, any new employer will ask the appellant to provide the copies of the letter dated so and so, so and so and so and so, referred to in the impugn order, and that if the said letters contain findings which were arrived at without a full-fledged departmental inquiry, those findings will amount to stigma and will come in the way of his career. Now, in this case, my lord, the petitioner's termination order is beautifully written, no stigma. but the background under which, my lord, the termination order has been written, it is reflected in the, my lord, affidavit in opposition filed by the government, particularly at paragraph, my lord, 12, 16, 17, 18, and 19. The motive is also there, ground is also there. Full-fledged inquiry was conducted, petitioner is, and my lord, this is the, my lord, stigmatic, my lord, conduct they have done. This 12, paragraph 12, 16, 17, 18, and 19, that your lordship will get it from page 128 to 133. So, main questions which I was submitting before the court is that whether he is going to get an employment in future. Paragraph 25.
Just a moment. Page 128 to 133.
Yes, ma'am. I'm not going because your lordship has gone through, many of my learned colleagues have taken your lordship through that. Because that is the basis of the order of termination. Basis is there was a inquiry, there is a findings, and on the basis of that, so why you are terminated? Because you are involved in that. He according to me, he is simply, my lord, entitled to get a notice that your question paper or your answer paper is not from the press. What do you want to say? That he is entitled to get it. He has got many answers. On the basis of that, if the authority wanted to dismiss him from service, that would have been fine. But with this kind of, my lord, stigmatic, my lord, materials, his life is finished, my lord. And that cannot be done. This is what the Supreme Court says, without giving him notice under as per provision of law, Article 311. Now, paragraph 25. In the matter of, may I read, madam?
Yes.
In the matter of stigma, this court has held that the effect which an order of termination may have on a person's future prospects of employment is a matter of relevant consideration. In the 7-judge bench of decision of the so-and-so, Justice led by Chief Justice Ray, observed that if a simple order of termination was passed, that would enable the officer to make good in other walks of life without stigma. So, question before the court, I will pose again, my lord, whether this man can move around freely, my lord. It was also stated in so-and-so that if the order contained a stigma, the termination would be bad for the individual concerned, must suffer a substantial loss of reputation, which may affect his future prospects. Paragraph 26. There is, however, considerable difficulty in finding out whether, in a given case where the order of termination is not a simple order of termination, the words used in the word can be said to contain a stigma. The other issues in the case before us is whether, even if the words used in the order of terminations are innocuous, the court can go into the words used or language employed in other words or
orders
referred to by the employer in the order of termination. So, if your lordships go into all these things, my lord, the termination order is merely, my lord, camouflage. The ground is in the affidavit. Paragraph 27 is meaning of stigma. As to what amounts to stigma has been considered in so-and-so case, this court explained the meaning of stigma as follows. According to, so the meaning is there, my lord. It is a disrepute, imputation, mark, disgrace, or shame. This is a very serious allegation, my lord. The allegation is that your answer script doesn't match with the printed answer script of the APSC. Very serious allegation. One line notice to him. What do you have to say? He is entitled to one. Otherwise, now he is running out, my lord. He is in the society with that reputation. Well, in the order of in paragraph 29, I'll read again. from the middle, my lord, that such as from the middle, my lord, rules, there would be no question of characterizing that simple order of termination as one founded on the allegations which were the subject of inquiry. That is, if the termination is done on the basis of the rule without inquiry. That was because in such a case, the purpose of the inquiry was to find out if the officer was to be continued in service and not to find out if he was guilty. Well, it is just like, my lord, compulsory retirement also. Paragraph 30, last part, my lord. Paragraph 30, last part, that is in regard to compulsory retirement. Same thing, my lord. Paragraph 30, last line.
30.
That is in regard to, I'm not reading the whole paragraph, in regard to compulsory retirement. Any person reading the letter or the order of compulsory retirement would not be led to believe that there was something wrong with the appellant too as regards his conduct or character. They would only indicate that he had ceased to be useful to the bank in his capacity as a manager. So purpose is that if you are inquiring into the matter, in the midst of the inquiry, you can leave, saying that, okay, we don't want you. So in a probationary period, it can be done in this manner.
But Mr. Das,
My lord,
I'm just giving a practical example.
my lord.
One person who is the president of a country had been declared bankrupt thrice. So reputation.
Lordship, I must sorry to come in for a moment, but for my own knowledge, this one I'll also have to check on Google. I would normally consider myself to be reasonably well versed with this kind of information, but a president of a country being declared bankrupt thrice is something new for me also. I need to check on this. I'm grateful for that input.
No, this is hot news everywhere. Every day this is a frontline news.
I got it, Lordship. I didn't realize about the bankruptcy. That was a very witty one also, I must say, Lordship.
Then paragraph 33, last part, my lord. It is a bank manager's case. Well, I better read paragraph 34.
32.
34.
34.
It will be seen from the above case that the resolution of the committee was part of the termination order being an enclosure to it. But the offensive part was not really contained in the order of termination, nor in the resolution which was an enclosure to the order of termination, but in the manager's report which was referred to in the enclosure. The said report of the manager was placed before the court along with the counter. The allegations in the manager's reports were the basis for termination, and the said report contained words amounting to a stigma. The termination order was, as stated above, set aside. So the report was relied on. Here, your lordship will look into the inquiry report of the police officer. The above paragraph 31, the above decision is, in our view, a clear authority for the proposition that the materials which amounts to stigma need not be contained in the order of termination of the probationer, but might be contained in any document referred to in the termination order or in its annexes. Obviously, such a document could be asked for or called for by any future employer of the probationer. In such a case, the order of termination would stand vitiated on the ground that no regular inquiry was conducted. We shall presently consider whether, on the facts of the case before us, the documents referred to in the impugned order contained any statement. So this, your lordship may look into what is the reason for, my lord, termination, and that reason is there in the government affidavit itself, and that affidavit, contention in the affidavit is stigmatic or not. That is my simple submission.
If it is stigmatic, that we are open for regular proceeding.
So ultimately, my lord, the order passed by the learned single judge and the division bench was set aside. And the purpose of my citing this case is, my lord, whether stigmatic or not, your lordship can look into the materials before the court, or your lordship may also call for the records from the authority. Here the affidavit in opposition has been filed. It indicates, and your lordship is to decide whether the contention raised in the affidavit is stigmatic or not. In my humble submission, it is out and out a stigmatic order, stigmatic, and the person cannot be, my lord, terminated in a manner
37.
which has been terminated. My lord, even, my lord, in a Dhingra's case, 1958 Supreme Court, one paragraph, my lord, paragraph 20. My lord, paragraph 28, my lord, only one line, my lord.
28.
28. If it is found on misconduct or disqualification, then it is stigmatic. In short, my lord, in paragraph,
Just a minute.
after line about second page, top, my lord. Paragraph 28. In the middle, your lordship has seen, my lord. In short,
Para 28, how does it start?
it starts, my lord, the position may therefore. Paragraph 28. As your lordship.
Just a minute.
Jhalak ki baat nahi.
The position may.
Yes.
Yes.
Yeah, my lord, after that, my lord, in short, after about 10 lines,
Yes.
in short, your lordship has found.
Yes.
In short, if the termination of service is founded on the right flowing from the contract or the service rules, then prima facie, the termination is not a punishment and carries with it no evil consequences, and so Article 311 will not attract. But even if the government has, by contract or under the rules, the right to terminate the employment without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reductions in rank, the government may nevertheless choose to punish the servant, and if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualifications, here, my lord, his other disqualification, he has misconducted himself in the examination process, then it is a punishment, and the requirement of Article 311 comes in. So, my lord, in this background, my lord, taking into consideration the order of termination and affidavit, this is a taking into consideration this aspect of the matter, I humbly submit before this court that the order of termination is stigmatic and therefore it is liable to be interfered with. No government, I don't think government of Assam or government of India, even the High Court will accept petitioner's application for employment. And what is his position in the society, which has been done prior, without any notice to him. It's a great thing, it could have been done in just 10 minutes. They have such a big officers and talented officers, my lord. They could have done by giving a notice that this is your. This is your conduct. This is what we have found. So my submission is short, my lord. The termination order is camouflaged and it is an stigmatic one. Oblige, Your Lordship.
Others want to. Others have-
Other points
You are
I
adopting
had-
other arguments.
Yes, I don't want to burden your lordship with repeated arguments. Oblige.
This is your lordships. Lordships, I appear in item number 43 and 42. That is writ appeal 31 and writ appeal 26 of 2021. 43 and 42. Yes.
Yes.
Yes, Lordship, Lordship may take up item number 43. 43 and 42 are same, both belong to Assam Police Service. Both were appointed in the same date. Their suspensions are also on the same date. Discharge orders are also passed on the same day. So 43 will cover both of them. So herein, Lordship, the appellants before your Lordship were appointed on 13/10/2016. Assam on probation to the Assam Police Service Junior Grade, Lordship. Page 80 of my memo of appeal, Lordship will find the appointment orders. Therein one of the appellants is in serial number 7, page 80 of my, and the other appellant is in serial number 33. So I was appointed on 13/10/2016. Thereafter, I was discharging my duties, Lordship. And in the meantime, as your Lordship knows, most of the submissions have been made and FIR was lodged in the month of October 2016. Pursuant thereto, an investigation occurred and we were arrested, Lordship. So now if your Lordship comes to page 82, 82 is my suspension order.
Yes, please read that.
Lordship?
Please read that.
Yes, Lordship, there is page 82. It's dated 5/11/2018. Whereas a report has been received from Superintendent of Police, Dibrugarh, wide number so-and-so, dated 22/10/2018, that's Sri Bhargav Fukan, APS, Deputy Superintendent of Police, Mankachar and District Attachment at South Salmara, Assam, has been arrested in connection with Dibrugarh PS case number 936 of 2016 under section so-and-so, which is unbecoming of a police officer. And now, therefore, the Governor of Assam is satisfied that it is necessary and in the interest of public service to place the Bhargav Phukan, APS, so-and-so, under suspension with effect from 18/7/2018, that is the date of arrest. Accordingly, the Governor of Assam, date of arrest pending drawal of departmental proceedings, Lordship. This is important. Accordingly, the Governor of Assam is pleased to order that Sri Bhargav Phukan is deemed to have been placed under suspension under Rule 6(1) of the Assam Service Discipline and Appeal Rules 1964. So the suspension order was passed under Rule 6(1). So 6(1), Lordship, there are 3 criteria. It's given in A, B, C. They don't mention it specifically since they have stated that pending drawal of departmental proceedings. So I'll assume that the suspension orders were passed under Rule 6(1)(a). Rule 6(1)(a). So this suspension order was passed on So rule 6(1)(a), I'll just read it out for your lordship. It says the appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant under suspension where a disciplinary proceeding against him is contemplated or is pending. And in the suspension order, they have said that pending departmental proceedings. So thereafter, lordship, this order was passed, suspension on 5/11/2018. So wherein they contemplated this holding a departmental inquiry, but they have not conducted any departmental inquiry. And what they have done is, your lordship may kindly come to page 83. Those are my discharge orders, if I may read, lordship. So discharge orders, in very innocuously worded, they say that the government of Assam, in exercise of power conferred by Rule 16B of the Assam Police Service Rules of the Assam Police Service, is pleased to discharge Sri Bhargav Phukon, APS Probationer, Deputy Superintendent of Police, from service under suspension from service with immediate effect. So 5/11 the suspension order was passed, and within a period of 3 weeks or just a little above, the appellant herein was discharged. Both the appellants were suspended on the same date, and the discharge orders are of the same date, lordship. So herein for a lordship, 16B, if I may read out for your lordship. 16B says that discharge of a probationer shall be liable to be discharged from service, or in the case of persons appointed to the service under clause B of Rule 5(1), be reverted to the post of Inspector of Police if it is considered that is B, if it is considered otherwise unsuitable for reasons to be recorded for continuing in the service by the governor. So Rule 16B, your lordship will find it is somewhat similar to Article 311(2) clause proviso B. That also says that reason has to be recorded. But I have just placed the discharge order before your lordship. No reasons have been recorded. Nothing has been stated in the order. A simple discharge order has been passed. So my first submission in this regard will be, lordship, if your lordship takes the Rule 16B as in whole, your lordship is aware that the statute or a rule has to be given its literal and plain meaning. So it says that a reason has to be recorded. Since no reason has been recorded in this discharge order, my first submission is that on the basis of Rule 16B, this order is not sufficient. So this order has to go, since Rule 16B has not been complied with. So that is my first. Second, your lordship will come. I'll not take lordship. Rule 15 and Rule 17 of the Assam Police Service Rules 1966 are regarding the period of probation and the confirmation of service. The criteria enumerated therein in Rule 15 and 17 of APS rules, here both the appellants have crossed those criteria, lordship. So now your lordship may, and your lordship is aware that if an innocuously ordered discharge order has been passed, it has been submitted by my esteemed seniors a lot of times before your lordship, then your lordship has the powers to lift the veil and look into the records, which they have submitted before the learned single judge. The official notings and everything was submitted. And the learned single judge has recorded also what was there in the official file notings that was supplied before the honorable single judge. In paragraph 43 to 44, 45, it has been noted there of the impugned judgment, lordship. So now I'll take your lordships to a first thing. I'll just like to show that, lordship, the suspension orders were passed on 5 November 2018, and within a period of 22 days, they immediately discharged me. Suspension orders contemplated of holding a departmental inquiry. So the natural corollary in that fact is 6(1) I was suspended under 1964 rules. So when they say they're contemplating a disciplinary proceeding against me, Rule 9 of the 1964 rules should have been followed. But instead of doing that, they have passed an innocuous order and discharged me from my service, lordship. So in this regard, I'll just like to place two paragraphs. This decision was taken very hastily, lordship. Very hastily within a period of 21 days. So if your lordship just comes to Inderpreet Singh Kalo for a moment, lordship, just two paragraphs of Inderpreet Singh Kalo.
If 21 days is hastily, I'm just thinking about my own conduct, where we hear and pass on order there and then.
But your lordship,
I
lordship
don't
goes
know.
to the
I don't know.
entire aspect of the matter, and lordship writes a detailed order. So that is
No,
there is
no,
a
no,
bit
I'm
of difference in that. So I'd
It's
like
just
to
a
humbly
query which came to my mind. I don't say it's a correct query, but
Yeah.
just crossed my mind.
because no, that is because lordship has to apply. Lordship goes through every statutes, every judgment, rules, whatever is pleaded in the case. So it will naturally take some time, lordship, to come to a correct finding, to give a good judgment before this honorable court. So lordship may just now come to Inderpreet Singh Kalo, 2006, 11 SCC 356. Just two paragraphs I will place. Paragraph 71, lordship. Before placing these paragraphs, I would like to state that the stage where we are, the appellants, are almost similar to the case of Inderpreet Singh Kalo, lordship. The only difference is, till date, an exercise has not been done, a judicial exercise or an exercise by a competent authority to separate the tainted from the non-tainted. And that has been done on the basis of a police report. That your lordship knows, and that has been shown to your lordship. So paragraph 71 for a moment, lordship. That is your lordship's, my
Just a
lord,
moment.
paragraph 71.
Just a
Oh,
moment.
sorry, lordship. Lordship, para 71. Has the Lordship got it? If I may read, para 71. Furthermore, a decision in undue haste was taken so far as the nominated officers are concerned, whereas a note containing 90 pages was sent to the Chief Secretary of Punjab on 22/5/2002. The services of all the officers were terminated on the next day. Apart from the materials which have been relied on in the report, no further evidence was probably brought in between 23/5/2002 and 24/8/2002 when the services of the executive officers were terminated. Next paragraph, Lordship. It is thus furthermore beyond anybody's comprehension as to why action had to be taken in undue haste. 73. We do not intend to suggest that in any emergency it was not permissible, but we have not been shown that any such emergent situation existed. It was in any event necessary for the state to show as to how the records moved so as to satisfy the conscience of the court that there had been proper and due application of mind on the part of the authorities concerned. An action taken in undue haste may be held to be malified, the Lordship.
You will find a reported case in SCC.
Yes.
I forget the names of the parties. Customs and Central Excise.
Yes.
There the appellate tribunal, the Commissioner Appeals, heard a matter for quite a long time. And on close of the argument on the next date, he delivered a 100-page judgment.
Okay.
That was set aside on the ground that it was passed in undue haste. And therefore, this officer landed in some trouble.
Yes.
DP was drawn up and those things were there. When the matter came to Supreme Court of India, Supreme Court appreciated the effort of the officer to write a 100-page judgment on one day and said that it is quite possible to deliver the order in one day because he must have started dictating the judgment since the day one he had started hearing it. So it's quite possible.
Yes, Lord.
So therefore, what is undue haste is again something which is very subjective. Undue haste, one day can be a undue haste. 100 days may not be a undue haste for some matters. So we don't know.
Yes.
How would one define? There's no straitjacket formula to define undue haste.
Facts of each case has to be looked into, Lord. So here I'm just pointing out because on 5.
I think Mr. Kohli has a team, they can find out that judgment.
Even I'll try to
In
find
fact,
out.
Lordship, we've noted it down.
100-page judgment in a day by Customs and Central Excise.
Sister, we'll come back to you on this, Lordship, certainly.
Even I'll try to go through that judgment, Lordship. Now, Lordship, if I may continue, Lordship. Lordship, now the same judgment. Other paragraphs, it starts from paragraph 118. I'll not bother
The last paragraph was paragraph?
These paragraphs are 71, 72, and 73. That undue is what I've shown, Lordship. So, now, Lordship, the other paragraphs will be from 118 to 123. This I'll not read the entire paragraph, Lordship, because my senior, Mr. NNB Chaudhary, has already gone through this judgment before your Lordship. So, one paragraph I'll just read, that is 123. It's just 3-line paragraph. If I may read, Lordship. When the basis of termination is serious allegations of corruption, then it is imperative that the principles of natural justice must be fully complied with. So in this case also, Lordship is aware that the termination was on the basis of serious allegations of corruption, and those corruption allegations your Lordship will find in the police report. So this is what I wanted to show from Inderpreet Singh Kalu, and I've already stated, Lordship, our matters and the case of Inderpreet Singh Kalu will be almost in the same footing, Lordship, because from paragraph 118 onwards, if your Lordship goes through, the allegations are more or what similar, Lordship. And in this case, Lordship, the discharge orders were interfered with and the matters were remanded back to the High Court. And the High Court was requested to form a committee and to do the necessary exercise to separate the tainted from the non-tainted, Lordship. So next, your lordship, I'll take your lordship straight away to the impugned judgment because I'll not take much time. Most of the arguments have been placed before your lordship. So impugned judgment, I'll just cite the paragraph, lordship, and if your lordship permits, I'll not even read those paragraphs because lordship has already read those paragraphs of the impugned judgment. I'll just give a brief of what is there in those paragraphs. So the findings of the honorable single judge, your lordship knows it's from paragraph 43 onwards. So that is in page, in my appeal memo, it starts from lordship, para 41, para 43 starts from page 275. Para 43, lordship, the learned single judge have taken note of the fact that the office files containing of the entire petitioners herein, before the single judge, 52 of them, and regarding all of them, office files were produced before the learned single judge, lordship. Herein, I would like the learned single judge, if I may read just 2 lines of paragraph 43.
Yes.
Learned single judge have categorically stated what was there in the office files. So, para 43, third line first. The original office files containing the notes on arrest and suspension of the petitioners, as well as the notes on the decision making process involving consultations with an approval accorded by high government authorities, are perused. So next, after the file numbers were gone, the grounds of arrest and the materials collected against the petitioners are contained in the aforesaid office files. So lordship may kindly note, there was nothing placed before the honorable single judge to judge my performance. How was I discharging my duties during the time I was in service? That was for more than 2 years, lordship. So the only thing that was placed before the honorable single judge was that the police reports and the decision making process. And your lordship is aware, my esteemed seniors have taken your lordship through the records very patiently, lordship. Therein, your lordship, apart from the police reports, nothing has been considered. And all this exercise, the decision making process, that was done by the concerned state authorities, lordship, this was done behind the back of the appellant. So the moment you conduct an inquiry, may it be a preliminary inquiry of grave allegations of corruption, and then we are entitled to at least a notice, lordship. The principles of natural justice, as has been developed since 1978 from the Maneka Gandhi's judgment, lordship. Administrative authority are also bound by it. So that is my humble submission, that this entire exercise was done behind our back. Thereafter, the findings were arrived, and we were discharged on by a very innocuous order, lordship. So, lordship, in this matters, I'll urge your lordship, since the official file records were earlier also produced before the learned single judge, so to lift the veil, so lordship may go through the office notings, lordship, and very humbly, I'd like to submit then under Article 226, a roving and fishing inquiry is not to be conducted, lordship. It has to be seen whether the discharge orders were based on any allegations of misconduct. And it is apparently, a police report is nothing but a stigmatic report, lordship. And it can be said to be punitive also. That entails a person to civil consequences. The moment that comes into the picture, as has been very well recorded by the learned single judge in para 47. The learned single judge in para 47 has categorically stated that the investigating reports of Dibrugarh police were the foundational facts. The moment a court of law comes into that finding that a police report are the foundational facts, then there is no escaping from Article 311(2) or the principles of natural justice, lordship. That can be a post-decisional hearing also, a pre-decisional hearing also, that your lordship is aware. So, this and in that regard, lordship, I have made a very short note, lordship, where because most of the judgments your lordship have already gone through. So, if your lordship permits, I can give the notes, lordship. I'll just, the citations are mentioned there. I'll not read the entire paragraph, lordship, because the law is more or less, lordship has come to know about it. For note to extra So in regards to 311 and 2, I would again like to show Lordship there is a one more thing, Lordship, before I go there. In paragraph 46, the Honorable Single Judge has made a distinction, Lordship. He has said that a misconduct, if any, it relates to pre-recruitment. So the benefit of 311(2) or natural justice will not be given to us. Since there is a marked distinction between a misconduct that has occurred prior to me being born into cadre or prior to me being born into cadre. In that regards, your Lordship has already gone through a judgment. Paragraph 11, my senior Mr. A.K. Bhuya has cited in paragraph 11 of the impugned judgment. That citation is there, 2015, 15 SCC 5151. So therein was also a case of illegal appointment. The person was not qualified, but he was appointed in a different category. Thereafter, complaints were lodged. He was discharged from service. Supreme Court looked through the entire judgments from 1958, Purushottam Lal Dhingra, 74, Shamsher Singh, and all the judgments, Lordship, Anup Jaswal and all. And thereafter, the Supreme Court came to a categorical finding that when the discharge was based on misconduct, the protection under 311(2) or for that matter of fact, natural justice hearing has to be given, and the discharge orders were interfered with. I have, in my note, I have categorically wrote down the paragraph, Lordship. So to save time, I will not go through it because your Lordship has gone through the judgment earlier also. So that now next comes Lordship. As your Lordship know, my senior Mr. NNB Chaudhary has submitted that separate yardsticks have been taken up by the state authority, Lordship. In case of similarly situated persons with similar allegations, similar stage of trial, they are taking a different yardstick. And in case of us, they are taking a different yardstick. And in that case, Lordship, that amounts to violation of Article 14 and 16. Two judgments, Lordship, of the Honorable Supreme Court, already shown to your Lordship by Mr. Chaudhary. I'll rely on that same, and those paragraphs are also there. Just one paragraph I will read out of a 1979 judgment, Lordship. That is 1979, 1 SCC 477. This is the Manager Government Branch Press and Another versus DB Beliappa. Para 19, if I may read, Lordship.
Yes.
The rest of the paras I'll not trouble your Lordship with. Para 19 says, it is now well settled that the expression matters relating to employment used in Article 16(1) is not confined to initial matters prior to the act of employment, but comprehends all matter in relation to employment, both prior and subsequent to the employment, which are incidental to the employment and form part of the terms and conditions of such employment, such as provisions as to salary, increments, leave, gratuity, pension, age of superannuation, promotion, and even termination of employment. It is further well established that Article 14, 15(1) and 16(1) form part of the same constitutional code of guarantees and supplement each other. If on any authority is needed for the above enunciation, reference may be made to the observations made by Justice so-and-so in so-and-so, Lordship. So, Article 14 and 16 has to be maintained, Lordship. When it comes to termination also, you cannot say that one person, similar allegations, will conduct a departmental inquiry on, whereas on the other hand, you will say that the similarly situated will discharge you simply. Same set of facts, same set of materials, everything is same, Lordship. So that is my another submission before. This fact was also, Lordship, not considered by the learned single judge. Very humbly, I would like to submit, Lordship. So it is like the parity among co-delinquents, Lordship. Now, 2000, then Lordship, I would like to, regarding 311(2), that judgment was also been placed, that is 2025 SCC online SC 459, Sarita Chaudhary versus High Court of Madhya Pradesh and another. This judgment has also been placed by my senior Mr. NNB Chaudhary, Lordship. Just one paragraph I will read out. I have marked the rest of the paragraphs. Just one paragraph number 12. If I may read, Lordship.
Yes.
Paragraph 12. The services of a probationer could result either in a confirmation in the post or ended by way of termination simpliciter. However, if a probationer is terminated from service owing to a misconduct as a punishment, the termination would cause a stigma on him. If a probationer is unsuitable for a job and has been terminated, then such a case is non-stigmatic and is and it is a termination simpliciter. Thus, the performance of a probationer has to be considered in order to ascertain whether it has been satisfactory or unsatisfactory. If the performance of a probationer has been unsatisfactory, he is liable to be terminated by the employer without conducting any inquiry. No right of hearing is also reserved with the probationer, and hence there would be no violation of principles of natural justice in such a case. So, Lordship, the other paragraphs also, it traces out the law from Purushottam Lal Dhingra. Every judgment is there, so I'll not bother your Lordship. It has been placed, but I have marked in my note, Lordship. So, what this paragraph 12 basically says, that the performance of the probationers have to be evaluated to come to a finding whether I am suitable or not suitable for the job. In this case, as I have already shown to your Lordship, the office files were produced before the learned single judge. No performance, no service report, nothing has been placed before the learned single judge. Only the materials collected by the investigating officer of Dibrugarh police station case number so and so, and those were taken into consideration by the judicial department, and other opinions from high persons were also sought for. Those are all recorded in the impugned judgment. So I'll humbly like to submit, the moment you go beyond the performance of a person to consider his suitability, unsuitability, the same will amount to being a misconduct. And in that case, the protection of 311(2) or the principles of natural justice has to be followed, which is not done in our instant case. And the Honorable Single Judge has not delved into the matter of the protection under 311(2) or the application of principles of natural justice, because he says that whatever we have done is a fraud that relates to a time that is before we were born into our service. So he has not answered this. These are very important otherwise, Lordship. And whatever I could gather from the judgments of the Supreme Court, to my limited knowledge, that is the basic criteria of all the judgments, Lordship. The performance, if the performance is not conducted, and any inquiry, may it be a preliminary inquiry, is conducted behind the back, then the protection under 311(2) and the principles of natural justice has to follow, Lordship. So, and your Lordship is aware that my senior has made another submission before your Lordship, supplemented by a Supreme Court judgment, that charge sheet is nothing but a mere opinion of the investigating officer, Lordship. So, on a mere opinion of an investigating officer who is otherwise not fit or who is otherwise not fit to appoint or discharge the petitioners, can that opinion be the fact of discharging from our services? So that has to be looked into the and now, Lordship, just one last judgment, Lordship, just to say some paragraphs, Lordship, I'll not show the entirely 40 of the affidavit in opposition. There are certain paragraphs where they have stated that I have paid money, and my statement has been recorded by the police under 161 or whatever. So in that case, the elaborate submissions have been made. I'll just reiterate one line. I am there in the trial court appearing before these persons. 207 compliance was done. Now the case has proceeded, 27 witnesses has been examined, but till date, we have not got any copy from the learned trial court stating that and in our affidavit in reply, that is annexed here in paragraph, Lordship, paragraph 118 and 21 of our affidavit in reply, we have categorically stated that the reply is annexed with this application, Lordship. So, Lordship, now in paragraph 76, the last paragraph I will read of the affidavit in opposition filed by the single judge's orders. I have not taken your Lordship because your Lordship has already gone through the entire judgment a lot of times. And I have given my counters that everything was done behind the back. The entire office records were only police records, nothing else was there. And separate yardsticks have been maintained. So I have made my submission. So I was entitled to at least a notice or the protection under 311(2) or the principles of natural justice had to be followed, because fair play in action is very much needed nowadays, Lordship, even if it's an administrative action. So now your Lordship comes to page 184 of my appeal memo. I'll just read the last paragraph of that, paragraph 76. This is the affidavit filed in our case by the state.
Page number?
Page 184, Lordship, para 76 of the affidavit in opposition. The last paragraph, it is reiterated that the discharge order. If I may read, Lordship.
Yes.
It is reiterated that the discharge order dated so and so is entirely in conformity with law. It is denied that petitioner is deemed to be confirmed in service. It is denied that the discharge order casts or attaches any stigma. It is most respectfully reiterated that is always open to the state as an employer to have regard to any preliminary inquiry, including the investigation carried out by the police in the present case. Such material would form the motive for discharge of the petitioner from service and not the foundation thereof, and such the discharge order cannot to be said to be stigmatic. Any contention to the contrary would be unsustainable. So they admit in the affidavit in opposition a preliminary inquiry was done. And what was looked into the preliminary inquiry is only the criminal case records, Lordship, the police report. So the moment you take the police reports into account and nothing else, no documents relating to our performance or anything like that, then it is admittedly, Lordship, that is punitive, stigmatic, and entails us to the protection of 311(2). In this regards, if they, what is motive and foundation, just would like to place two paragraphs of one last judgment and I'll finish off, Lordship. It's 2005 SCC 152, Chandra Prakash Shahi versus State of UP and others. Motive is something that is in the mind of a person. And if it's the moment it comes out of the mind and you deliberate on that motive by conducting a preliminary inquiry, it transgresses into foundation and the protections under 311(2).
What is this, Harrison, 2005?
That is, Lordship, 2005 SCC 152, Chandra Prakash Shahi versus State of UP and others. Just two paragraphs of this judgment, Lord. Para 28 and 29.
Just find out. 2000, volume 5 SCC.
152. Page.
150. Yes.
If I may read, Lordship, para 28 and 29. Two paragraphs only. Small paragraphs. I'll read. Has your Lordship got it?
Yes.
28 or 29. The important principles which are deductible on the concept of motive and foundation concerning a probationer are that a probationer has no right to hold the post and his services can be terminated at any time during or at the end of the period of probation on the account of general unsuitability for the post in question. If for the determination of suitability of the probationer for the post in question or for his further retention in service or for confirmation, an inquiry is held and it is on the basis of that inquiry that a decision is taken to terminate his service, the order will not be punitive in nature. But if there are allegations of misconduct and an inquiry is held to find out the truth of that misconduct and an order terminating the service is passed on the basis of that inquiry, the order would be punitive in nature. What has been done in our case, Lordship? As the inquiry is held not for assessing the general suitability of the employee for the post in question, but to find out the truth of allegations of misconduct against the employee. In this situation, the order would be founded on misconduct and it will not be a mere matter of motive. Next paragraph. Motive is the moving power which impels action for a definite result. Or to put it differently, motive is that which incites or stimulates a person to do an act. An order terminating the services of an employee is an act done by the employer. What is that factor which impelled the employer to take this action? If it was the factor of general unsuitability of the employee for the post held by him, the action would be upheld by law. If, however, there were allegations of serious misconduct against the employee and a preliminary inquiry, para 76 of their affidavit, they also say they have held a preliminary. And a preliminary inquiry is held behind his back to ascertain the truth of those allegations, and a termination order is passed thereafter. The order having regard to other circumstances would be founded on the allegations of misconduct, which are found to be true in the preliminary inquiry. So, Lordship, para 76, the state has categorically stated in their affidavit that a preliminary inquiry was conducted, and admittedly, we are not a part of it. No notice was issued, and the preliminary inquiry only looked into the aspect of the police report. Nothing else was looked into.
There's a distinctive factor in this judgment of Sahi which you have shown.
Yes, Lordship.
If I remember it correctly, in this judgment, some rule was referred to, and
Yes.
that rule required that he should be put to notice.
That is the service rules of the. He was
I don't remember.
constable over there. Yes, that is there, Lordship. That is also there. The Lordship is correct about. That is also there. So I pointed out for that. And now, if your Lordship says that just one subject, last day your Lordship was asking about the seal cover documents. In here, Lordship, most of the matters, the seal cover documents were given before the learned single judge after some of the hearings of the learned senior counsels were over. So thereafter the documents were produced, and I'll like humbly submit the seal cover documents and the office files, everything was given in a seal cover. Everything. So, Lordship, my very esteemed senior Mr. Niloy Dotto, his submissions your Lordship will find from paragraph 19 onwards. 4 or 5 paragraphs of submission the learned single judge has recorded. So he was very categorical about one simple fact, Lordship, he was harping on. He was saying that the office files have to be looked into categorically. If that discloses any misconduct, then there is no escape. Then the provisions of natural justice had to apply. So, your Lordship, I have more or less stated whatever is there. So, Lordship, I'll just most humbly like to say, even though the discharge order is very innocuously worded, Lordship, but the moment your Lordship goes to the file notings, as have been categorically recorded by the single judge, your Lordship will find that misconduct is the basis of our discharge. And when the misconduct is the foundational facts of our discharge, then the protection under 311(12) or brief hearing or a notice has to be issued as per the principles of natural justice. So therefore, I'll pray before your Lordship to look into the matter entirety, and the relief that I have sought for in my appeal, if granted by your Lordship, would be truly applicable in the case. No, so whatever I have submitted before your Lordship in this item number 43, the same submissions will be also for item number 42. They were appointed on the same date. They are under the same rules, Assam Police Service rules. They were suspended and discharged on the same dates. Identical suspension and discharge orders, Lordship. So with that, Lordship, I'll conclude my submissions, Lordship. If something comes out from my learned senior friend from the other side, so I'll try to like satisfy your Lordship on that later on, if need be. Okay. Lordship, I'm highly obliged.
My pleasure, Lordship.
Yes.
Item number 28, Lordship. Lordship, first of all, Lordship, I'm appearing on behalf of AK Huya, Lordship. And Lordship, we adopt the argument made by learned senior counsel, Mr. Ken Chaudhary. And in addition to that, Lordship, item number 28, Lordship.
Yes.
addition to that, Lordship, we are relying upon a judgment reported in 2015-15 SEC 151 Ratnesh Kumar Chaudhary versus Indira Gandhi Institute of Medical Sciences, Patna, and the relevant paragraphs were, Lordship, 26 and 27, Lordship.
What is the citation?
2015-15 SEC 151 Ratnesh
Just don't rush. 2015.
15 SEC 151.
Paragraphs.
Paragraph 26 and 27. And Lordship, this appellant, he was discharged on 12/2/2019 under Rule 19(2) of Assam Taxation Services Rules 1995. And at that time, he was posted as in Kokrajhar as
You were discharged on which date?
12
12.
February 2019. And at the time of discharge,
The section.
under Rule 19, Sub-Rule 2 of Assam Taxation Service Rules 1995.
Yes.
And Lordship, at the time of discharge, Lordship, he was posted as Inspector of Taxes, Kokrajhar Unit. Lordship, the argument has been advanced by learned seniors, Lordship. Now, Lordship, I paragraph 46 of the impugned judgment, Lordship, passed by the learned single judge. Judgment starts from 513 of the writ appeal. Paragraph 46. Page 87. Lordship, page 599 of the writ appeal.
Yes.
In this paragraph, Lordship, learned single judge came to a finding that not a single citation could be placed on behalf of the petitioners for the proposition that irregularities committed during the recruitment process and or before appointments had been made and or before a person is born into a cadre service would constitute misconduct, Lordship. Lordship, to the contrary of this paragraph 46, Lordship. Page 58, 58, page 58. Page 570 of the writ appeal. In paragraph 11 of the impugned judgment. Page 570. The submission has been recorded by the learned single judge, honorable single judge, wherein two citations has been reflected, 2015-15, 151 and Carter Singh's judgment, Lordship. So, Lordship, this paragraph 46 and 11 is contrary on the face of the record, Lordship. And Lordship, now come to page 607 of the writ appeal. 605, Lordship. It's also. para 52 of the impugned judgment, Lordship. May I read this paragraph, Lordship?
605.
5.
605.
Paragraph 52 of the impugned judgment.
Yes.
On the above, first and foremost, the circumstances resulting in the discharge of the petitioners from service are undoubtedly exceptional. Some examinations involving petitioners in the main examination and their selection and appointment through an illegal process is the basis of their removal. Now, Lordship, if the whole process is illegal, then why some of the persons were still working in the same capacity and they have been promoted, and some of the persons were behind the bar, they were arrested, they were released, thereafter they were discharged from the service and they were before dishonorable court. The foundational facts as observed in the preceding paragraphs in the opinion of this court were sufficiently compulsive to take the petitioners out of their jobs. There was need for promptitude in taking stringent action. Urgency of the situation also demanded weeding out those identifiable persons who had entered into service through an illegal process. The opinion of the learned single judge is that whole process is illegal. The audiolter pattern rule tested on exceptional facts and circumstances of the present cases is not applicable, and the petitioners cannot be heard to demand an opportunity of hearing or to claim a right for post-decisional hearing. The disturbing disclosures in the investigation reports with regard to the prevalence of unfair procedure and tempering of the examination process for the benefit of the petitioners brings the present cases within the category and exceptions to the rule of audiolter partem. This opinion, Lordship, quoted by the learned single judge, is based on a police report which is at this time is pending for trial. Till date, 19 witnesses, as per my information, 19 witnesses has been examined. No witnesses has been named this writ appellant that he is engaged in any kind of misconduct or he indulged in any kind of this scam or illegalities which has happened at the time of, as alleged, which has happened at the time of entry in service, Lordship. Now, on that basis, the opinion has been framed by the learned single judge, and this is under trial. Trial is going on. That is the case record. Police report is not the finality. That cannot say that this police report will convict this appellant in future. In view of the fact that 19 persons has been examined, no one has stated. So, Lordship, on the basis of this police report, the discharge order, the whole discharge order came to a stage wherein that given a stigmatic to the future of this appellant. Without the proper trial, without the trial being held, and without the completion of the trial, and without convicted by the criminal trial court, this opinion is stigmatic, and this is not a final opinion, Lordship. This is a police report. This is not evidence, this is not substantive evidence, Lordship. And if in near future this person, as 19 witnesses has not named this person, if in near future, Lordship, these persons were acquitted, then who will be liable for the loss of the time of this appellate, Lordship? Now, that is why this impugned judgment based on passed on the basis of the police report is bad in law. And Lordship, the judgment which we have learned senior have argued in the writ petition also, learned senior counsel and Dr. Sir and other counsels were argued on the point of legality on and other aspects, Lordship. And I'm coming to the judgment which we are relying on 15 SCC 151, paragraph 26, Lordship.
You give us a list of
Lordship,
decisions.
This was already given. We have not given list, Lordship, because we have relied on in the writ petition also, and this was relied on by other counsel
no.
also, Lordship.
I won't be fishing out those citations. You write in a piece of paper and give it to us. We'll not be able to track this again.
Then Lordship,
Give a-
after.
After this, you can give it tomorrow morning.
Yes,
Give it to the
Lordship.
courtmaster.
Paragraph 26 of this.
And if
judgment.
I can also, Lordship, request that they give us a copy. Because or she can tell us the citations, we can note it.
This is, she's relying on Ratnesh Kumar Chaudhary.
Ratnesh Kumar Chaudhary.
We have it. We have it.
Paragraph 26, Lordship. May I read, Lordship?
This we have already, or it has already been cited.
Yes, Lordship, this was cited by other counsels also, Lordship.
Not
We are also relying on this judgment, Lordship, where there is stigmatic view, where the
Paragraph
order
numbers?
is punitive.
Para
Then,
numbers?
Lordship,
Paragraph numbers?
26, 27.
Yes, this has been cited.
As the discharge order and the impugned judgment was based on the police report, and misconduct has been described against the writ petitioner, appellant, then a notice and a proper hearing should be given to him as to why he has been discharged and as to why a proceeding has been initiated against him, that this type of questions arise against him. That was not taken into consideration in this case, Lordship, and on the basis of police report, Lordship, this whole judgment is false flat, Lordship, and if the entry into service is bad as per the respondent's entry into service is bad, then why some persons were in the office and other persons were deprived from their legitimate, Lordship, entitlements? This is my humble submission, Lordship, and petitioner is entitled to get a relief from this court, Lordship, as the impugned judgment is not on the basis of record and on the basis of law prevail in this, Lordship, natural justice and 311 and other provisions of this, Lordship. This is my humble submission. And Lordship, there is another judgment we are relying on, Carter Singh's judgment, Lordship. That is 1994, 3 SCC 569. And Lordship, this judgment, we are relying on, Lordship, 1994, 3 SCC 569.
Also enter this into the list of dates, list of books and give it to the courtmaster.
And this,
indicate the paragraph also.
Lordship, I will cite the paragraph.
Yes.
So, and in this judgment, Lordship, we are relying on as the some of the witnesses that is called approvers, alleged approver, on the basis of their statements and on the basis of this police report, the whole basis of this opinion has been arrived, and one co-accused statement cannot be treated or used against the other co-accused. That is the law of the land, and this judgment will state this, Lordship. This is my humble submission.
Mr. B.D. Das, Learned Senior Counsel, assisted by Mr. H.K. Sharma, Learned Counsel, for the appellant in WA 128 of 2020. Mr. M.K. Chaudhary, Learned Counsel, for the appellant in WA 26 of 2021 and WA 31 of 2021. So also had Ms. Ann Chaudhary, Learned Counsel, appearing in WA 137 of 2020. Other counsel who want their name to be recorded, please give it their names to the court master. Ms. Chaudhary, you are there. Ms. B. Chaudhary, learned counsel in WA. What is the appeal number? 14 of 2022. Is present. Next person also present is Mr. N. Koril, senior counsel, assisted by
Mr. A. Roy, Miss Nimisha Menon, N. Menon.
from last yesterday's audit on that,
Same.
along with Mr. H.K. Hazarika, and government advocate. Present. Next panel. List as a part and matter on tomorrow. 21. Just I know that the other council, the other applicants are present.
Grateful Lordship, Ladyship.
One bail application, Lordship, day after tomorrow.
Bail application, you'll have to move it before the,
No, Lordship has rejected earlier.
no, then please give it to the registry. Well, I don't keep a track of which matters were earlier dealt with me. So please give it to the registry, they will take it up.
And diploma.
Item 1 BA
No,
1152.
we'll first take up item 3.
Oh.
May I have an indulgence?
Yes, yes.
Somewhere I read, PA is within the parameters of Article 21. So it should get, I think, some precedence.
No, we wanted to release both of you. We,
No, my
knowing that both of you are extremely, no, you see this Mr. Pathak. In this case, I am in default.
Oh my God. I
So
court can
therefore,
never be on default.
no, it is. Court may not be, but I am in. So I need 2 more days to complete the
I
order.
understand your lordship was not well in between. And in between that, there are many division benches also.
These are part of the work.
Only
But I need two more days to complete it. I am now at the ending of the order. I'm just keeping it as half-parted because we have received advisories in the meanwhile. So therefore,
I have with 40 plus years at my back. I will not comment on certain things.
no, we understand that that's the goodness in
Because
you.
this is the highest court. So for the state of Assam is concerned.
No, that is the goodness of you, but still, what
This
has
is my
happened has
understanding
happened.
of what, this is my limited understanding of the constitution.
The framework is already made, but just 2 days more and
That's
Yeah.
up. We should leave it to your lordship to. Yes,
fixing it again on 21st, hopefully on that, sorry, on Tuesday, hopefully on that date it will be completed. Uh, the at the re-hearing, heard Mr. K.V. Pathak, Learned Senior Counsel, assisted by Mr. I. Kalita for the applicant, as well as Mr. P. Nayak, Learned Counsel for the respondent. Most of the hearing remains inconclusive. List again on this Tuesday, 27.
27.
Hopefully, I'll be in a position to.
And it is might be already on record if my recollection is correct. I have also brought the same thing. Only difference is after when the hearing was going on in this case, in the other case it went to Supreme Court.
Karimuddin Barwe.
Karimuddin Barwe.
That's there.
Paragraph number 19, but that was not in the compilation. So may I, my lord? It is the same as before. Word by word same. I thought since Korimuddin Borbhe only a loose copy I gave,
But it's available.
it's right. Might be I may be incorrect also in my understanding of the constitutional provision. So what the state is concerned, High Court is the highest court.
No, correct. That's absolutely right.
Yeah.
And we have,
And it's not subordinate to anyone.
we have the judgment of Mirajkar also.
My lord, yes.
It's a constitution bench judgment.
It's not like your lordship directing sometimes some subordinate courts to do certain things in a certain manner. But this is the highest court of the land.
Where it would not lie.
My lord,
Where a writ would not lie.
it will not lie. This is my limited understanding of the
But
law.
that's also, I carried the same meaning, but
So I desist myself from commenting on anything.
this what. Okay, but I'm extremely sorry again.
No, my lord, that will be too much
No,
on
no.
my part if you're something like word sorry comes from that side.
No, it's, you see, I don't hesitate.
No,
If I have committed something which is,
I'm sure I had a talk with his senior also. It was a pleasure arguing before your lordship.
this goodness of you.
No, my lord, it should not.
So we keep this,
It is the same talk.
yes, it's here. This is here. You're going the citation wise and the highlighted points. The problem has come to now what has happened, the framework is ready. So many cases are cited that the re-going into paragraphs causes changes in the main draft. Once you read it, you have a different meaning. Then you again read it, you have a different meaning. Then again in one or two of the judgments, the context in which the judgment was made is shortened up, so you don't understand in the second case why it has been quoted.
My lord, I understand now. But one interesting point I developed in the earlier case, that while drafting an election petition, whether grounds should be shown or not, that might be, I had a difference with the lordship that time. Now it is a settled law.
Now
That
it's a
it is a settled law, grounds have to be done. Because election petition, there is a particular way of drafting, because section 81 say it shall be presented on grounds. So it has to contain grounds separately. That was, of course, now it is clear. The whole picture is clear now.
But in again one of the judgments, grounds has been diluted to say that the context in which
That yes, immediate. Now, that was initially a confusion was there in the apex court judgments. That moment something is alleged within the parameters of paragraph 49
yes,
of that democratic forum, that itself is sufficient to have a undue influence or corrupt practice.
yes,
Because a legal fiction was created. Then nothing was said whether section 83 and 81, that grounds should be stated separately. Now, I wanted to, with Lord's blessings, I wanted to expand it, that we should stick to, because it is not a common law, it is a statutory law. Now that has been made clear.
in which judgment?
In Korimuddin Borbhe, paragraph 24. Paragraph 24, that is at page, now this time I have annexed it. Paragraph 24 the lordship will get
This
it at
is
page 7.
this is not there in my notes.
Because not in this earlier case.
No, I understand, but this paragraph 24 is not in my notes.
Oh, I see. Now, in the apex court, it was again argued at length at page 70, page 69. Paragraph 24. Actually, from paragraph 19 onwards, and another confusion arose, as the lordship has rightly pointed out. Democratic association case, moment something is said that this is suppressed, whether the necessity of how, when, in what manner, that those things are necessary or not. Now that is now also explained because Azhar Hussain initially explained that how, when, where this is to be specifically pleaded because it cannot be adduced in the stage of evidence. After that, Azhar Hussain is pre-2002. Post-2002, there is no judgment. If it is so, it is corrupt practice. Now, in this judgment, in paragraph 19 onwards, it is said that how, when, how, where, and how this undue influence took place. That means it is referring to Azhar Hussain again. Because the classification has been made between the allegation and statement of material facts.
But in this case, the reference to Azhar Hussain is only with regard to the cause of action.
Cause of action, because now in this case, that unless and until when, how these are material particulars are not given, the complete cause of action in an election petition alleging corrupt practice will not hold good. Paragraph 19 onwards, that has been discussed. 24 is the grounds, why grounds should be stated in election petition. The same thing, my lord, even Itanagar bench did it. That Itanagar bench judgment is also there, that Kharikokri. At the last hearing stage, I went there. I tried to convince my lord, that bench. Court said that if this is not there, this is not necessary. In the next case, the apex court said no. The factual the who, how, when, the influence, undue influence took place, that has to be stated. Kharikokri, most probably I appeared for Kharikokri. He was a return candidate. Then I lost in the Itanagar bench. Then apex court reversed.
No, but in the earlier judgment, the grounds do not set out grounds. That has been interpreted that it should be based on the grounds. So that is the distinctive point.
Yes, sir. Initially, if your lordship might be knowing it, initially when I was wondering myself that when the facts are stated, then we make a separate chapter in election on grounds. Grounds has to correlate with the section 100. Now we state the grounds. Now in that earlier Korimuddin case also, the same here the problem. The grounds was not written separately. Then the court said that no grounds, you have to present it on grounds. Allegations must be now converted to grounds. Here comes the art of drafting an election petition.
No, grounds that's contemplated in section 100.
The grounds are contemplated because of section 81. Section 81 says the very presentation must be on grounds. If your lordship looks at section 81 of the RP Act,
No, here the reference to section 100 is on what?
the section 100 is the grounds. 81 is the 81. Your lordship will kindly look at 81. The language of 81 is
100 means 100 CPC.
no 100 RP Act.
100 is RP Act.
RP Act. And section 800 comes because of section 81. 81, if it is 81 is violated, may I just submit one thing. If
RP Act. No, representation is Mr. Pathak will need it. He will need it.
no,
Give me
I'll remember.
this.
I remember.
No, this first book. Yeah. This is the first one.
Yes, 81, the very presentation must be on grounds, as your lordship. Now, if 81 is violated, 86 comes. Your lordship will look at 86. 86. As your lordship. 86. If 81 is violated, 86. Now 86, there is a small explanation. If the dismissal is ground of violation of 81 for not having the grounds, that will be deemed to be a dismissal under 98.
Yes.
So 98 is at the conclusion of the trial. 98, your lordship, you can see.
Yes.
So the grounds has an important role in the matter of drafting of an election petition. Now, so in the matter of drafting of an election petition, the pleadings, so the grounds have to be specifically pleaded. So that was one of the point of argument in the apex court. So in paragraph 24, before concluding, they said that must be on grounds. And regarding that confusion that happened as to whether that moment someone raises an allegation that this is corrupt practice of undue influence, does it absolve the petitioner to say how, when, who, and in what manner he got influenced, someone got influenced? These are the material facts. So this is from paragraph 19. So these 19 onwards actually stick back to, again, Azhar Hussain and few other cases. Most probably my recollection, 19, 20, 21, 22, or 23.
22.
My lord, now. Because sometimes.
No, it's okay. No, because I just read it. 23 is other observation, then comes 24.
22. I'm still trying to learn it because sometimes I was always confused from 2001 that why this is, because Democratic Forum Association case, with all due regards to the judgment of the apex court, first of all, did not say, they only in paragraph 49, they say these are necessary. And Election Commission is directed to issue a notification. Then the government of India does a tussle game. They came for 33A. Now, 49 converted to 33A. Now, nowhere it was said that what will happen, consequences of not following that 49A. From, if your lordship goes through, most probably your lordship have already gone through all the judgments. None of the judgments says, like any judgments in between 2002 and 2022.
Then it says that it has to be.
If it
cannot be nil. Cannot be nil.
Yes. So that was resurgence.
Resurgence India.
Resurgence India effect. But what is the effect of it? Nobody was saying. Somebody said moment it will be taken as an undue influence. But does it absolve the petitioner to say the material facts of who, when, how? Then now in this judgment, again reverts back that no, undue influence because of non-disclosure or something. But who got influence? How he got influence in the exercise of his right to vote? It's a concept always developing.
Let's see.
My lord, it's a pleasure. Incredible.
Take up item 1 now.
Lord, I would like to withdraw this matter.
Item one,
Item one.
okay. Upon instructions, Mr. H.R. Chaudhary, learned counsel for the petitioner, seeks to withdraw this petition. Prayer is allowed. Matter stand dismissed on withdrawal.
Vice.
Mr. R. Kaushik, learned APP is present. Yes, item two,
May it please the Lord. Dear, otherwise I was ready with the case. The only thing, my lord, in the meantime, my lord, one of the co-accused, my lord, he has been granted the privilege of bail, my lord, on the ground that, my lord, that grounds of arrest was not there. So, my lord, I will be filing one affidavit, my lord, to that effect, my lord. Otherwise, on other grounds, my lord, I am ready, my lord.
no, can't be parted because I am already in two parted matters. Next week,
Lots of any day, yes, ma'am.
next week there will be a single bench at 2 o'clock, on Tuesday.
I want to point out one thing, Lordship, a very serious matter. But next bail application, when my management submitted, it was granted. Same application was pending before your Lordship for last one year. Then it was withdrawn, then it was taken to sign. If, classic
It's
example.
for you to,
Then something else.
you to take appropriate action.
No, that is there, but I take my duty to point out to you.
We understand, but
Also a different council, madam, we are not there.
no, whatever happens, but it's for you to take up the issue. Tuesday, next,
Madam,
we are having a single bench, otherwise this next week there will be no other single bench.
madam.
On the prayer made by Mr. H. Original counsel for the petitioner, based on 27th. So Mr. S.E. Kyal and standing counsel for the NCT is present.
Obliged,
In this issue, you also come prepared with one of orders passed by this bench.
yes, my lord, I had seen my lord, last my lord, until and my lord, those.
I don't remember the names, but
Yes, my lord.
passed an order and in such
No, on grounds of arrest, my lord,
on grounds of arrest.
that I have not found, I'll check up.